Good morning and welcome. The 73rd plenary session of the Administrative Conference of the United States will now come to order. We'll begin as usual with introductions. I'm Matt Leader, the conference's acting chairman, vice chairman, and executive director. Our 8 other council members have joined this morning. Ronald Cass, Jennifer Rickey, Jeffrey Harris, Donald McGann, Michael McGinley, Matthew Morgan, Roger Severino, and Adrian Renewal. 3 of our council members were appointed since the last plenary session. They are Jennifer Rickey of the Department of Justice, Roger Severino of the Department of Health and Human Services, and Adrian Renewal of Harvard Law School. Ron Cass, our longest-serving council member, was reappointed. Congratulations to all of them. And last week, the White House announced the president's intention to appoint Andrew Foster to the council. Since the last plenary session, 30 new voting and non-voting members have also joined ACUS. Their names appear on the screen. I thank them all for giving their time and talent to ACUS's important work. Not here today, sadly, is Judge Stephen Williams of the U.S. Court of Appeals for the D.C. Circuit, who passed away in July at the all-too-young age of 83. Professor and later Judge Williams was affiliated with ACUS as a consultant, public member, and then senior fellow for most of his career and most of ACUS's history. His contributions to ACUS, like his contributions to the federal judiciary, were inestimable. Moving tributes from ACUS members appear on our website. With those introductions behind us, I'll begin, as our statute requires, by reporting on the state of affairs of the conference since our last plenary session. The chairmanship remains vacant. Last Thursday, the White House announced the president's intent to nominate Daniel Epstein as the next chairman. As vice chairman, I've been serving as the acting chairman now for 4 years. In each plenary session during my tenure, I declared incorrectly that it would be my last. This time I can make that declaration with greater certainty. Allow me the indulgence of telling you what an honor and privilege it's been to work with all of you. Our long-term research agenda is for the next chairman to set in consultation, as our statute provides, with the council. My main job, as I've always seen it, is to ensure that we have enough projects directed to the formulation of assembly recommendations, free from the encroachment of partisan politics, to keep us busy until we welcome a new chair. I think I perform that job at least satisfactorily, if only because I've had the support of our council and the help of a first-rate ACUS staff. We have enough pending projects to keep the assembly busy through at least the next plenary session, if not beyond. I anticipate that we'll add 2 more projects. Our research director will review our pending projects tomorrow. I'll allude to a few now. I'll limit most of the remainder of my introductory remarks, though, to highlighting some especially notable activities, some completed this year, some soon to be completed, some ongoing, of the chairman's office. Our plenary sessions may give the impression that our work consists only of issuing assembly-adopted recommendations and their associated reports. But that's not the case. The chairman's office carries out many other activities that contribute vitally to the statutory mission. That said, I'm reluctant to draw too sharp distinctions between the projects of our chairman's office and those of our assembly. Studies of the chairman's office often present issues for the assembly's eventual consideration, and the reports associated with the assembly's recommendations often serve valuable functions in their own right. No doubt one of ACUS's most important functions is to provide a forum for agencies to share information and perspectives in a more informal venue than our plenary sessions. The chairman's office continues to facilitate this interchange through regular meetings of the Council of Independent Regulatory Agencies, or CIRA, which dates back to the 1980s, and the Interagency Roundtable, which we established last year. CIRA is comprised of ACUS members from independent regulatory agencies, the roundtable of all government members. All conference members are invited to attend roundtable meetings. Just this fall, the chairman's office established a 3rd such forum, the Council on Federal Agency Adjudication.
The council will provide a much-needed forum for the heads of agency adjudicating offices to exchange information about procedural information, best management practices, and other subjects of mutual interest. It will also provide a forum for ACUS to identify new areas of adjudication to address in its studies. A consultative group of scholars with expertise in adjudication, some of them ACUS members, will share their research and expertise. The council will be chaired by former ACUS chairman Paul Verkyle, Adjudication Committee Chair Nadine Mancini, and me. Our working group on compiling administrative records, which I mentioned at our last plenary session, has had an especially productive year. The chairman's office established this group at the suggestion of the Assembly in a 2013 recommendation to prepare a guide on the preservation, compilation, and certification of rulemaking records for judicial review. The group will complete its work on the guide shortly. This year, we have stepped up our already significant efforts to serve as a resource to agency lawyers. One example is the COVID-19 resource guide recently published on our website. It catalogs and links to agency policies governing adjudication hearings and docket management during the pandemic. Another example is the monthly information interchange bulletins that I hope you've had a chance to review. These one-pagers address administrative law issues that agency lawyers frequently encounter in their work. We also just initiated a program to collect innovations in administrative procedure from states and share them with federal agencies. I thank our senior fellow, Lee Lieberman Otis, for just suggesting this idea several plenary sessions ago. A relatively new resource on our web page is the regularly updated electronic edition of the Federal Administrative Procedure Sourcebook. Published jointly with the ABA section of Administrative Law, the Sourcebook provides an annotated compilation of the legal authorities, APA, FOIA, rulemaking executive orders, and so forth, governing nearly every aspect of administrative procedure. Our Deputy Research Director, Jeremy Grayboyce, edits the book. Two ACUS members representing the ABA, Professor Jeffrey Lubbers and William Funk, serve as editorial consultants. Jeff and Bill wrote successive editions of the book, while until several years ago, it was housed at the ABA, and they are largely to thank for the book's current content. Surely the most notable publication of the chairman's office this year was Government by Algorithm, Artificial Intelligence in Federal Administrative Agencies, written by Professors David Freeman and Daniel Ho of Stanford Law School, Professor Catherine Sharkey of NYU, and Justice Tino Cuellar of the California Supreme Court, formerly Professor Cuellar of Stanford and formerly ACUS council member Cuellar. This is the closest ACUS has to a bestseller. The book-length report canvasses the most significant uses of AI at nearly 150 agencies and analyzes the institutional, legal, and policy challenges raised by AI. Numerous agencies at the forefront of the government's AI initiatives, including GSA, GAO, and the Office of Science and Technology Policy, have already put the report to extensive use. You'll hear more about it tomorrow when we take up the statement on artificial intelligence. The report is one of two that underlies the statement. The other, of course, is Professor and public member Carrie Colonesi's similarly outstanding and complementary report, A Framework for Government Use of Machine Learning. This sophisticated yet accessible report provides a cogent analysis of the legal issues associated with the use of AI, and most importantly, offers guidance to agencies when deciding when to deploy analytic tools that rely on AI. The chairman's office published two other notable reports this year. The first was Administrative Recusal Rules, a taxonomy and study of existing recusal standards for agency adjudicators, written by Professor Louis Farilli. This report will serve as an important resource to agencies as they review existing and adopt new rules governing the impartiality of adjudicators. You may recall that in 2018, ACUS adopted a recommendation providing that agencies should adopt recusal rules for adjudicators and procedural mechanisms for their enforcement. We found that many agencies don't have them. The second report is Jeremy Grayboyce's Legal Considerations for Remote Hearings and Agency Adjudications, which obviously comes at an especially opportune time. As Reeve Bull will mention tomorrow, we've begun a project on how to conduct remote hearings that will reach the Assembly next year. Jeremy's report will certainly inform that project. The Chairman's Office has also commissioned 3 other reports that will arrive next year. The first will return to a subject to which ACUS, at Congress's direction, devoted substantial time during the early 1980s, Alternative Dispute Resolution, or ADR. Our report will survey how agencies across the federal government use and might better use ADR to resolve agency adjudications and forestall federal court litigation. One statutory purpose of ACUS, it bears mentioning, is to prevent unnecessary litigation. The second forthcoming report will address the assignment of both enforcement and adjudicative functions to agency heads. We're fortunate that Professor Michael Asimov, who wrote our recently published source book on adjudication, has agreed to write this report. And the third is a report that will classify and catalog the many different types of guidance documents that agencies issue, from the formal to the very informal, and identify considerations that result in the use of one type of guidance document rather than another. The report may very well suggest the need for yet additional attention by the Assembly to the irrepressible challenges associated with guidance. Our committee chair, Kristen Hickman, and Deputy Research Director, Mark Thompson, are writing the report. No doubt, though, the most anticipated publication is the forthcoming source book of federal judicial review statutes. Tomorrow, the source book's author, Professor John Siegel, the conference's former research director and now a public member, will preview its contents. I'll reserve further comment on the source book until then. I would point out that the picture on that you have up on your screen is not John Siegel, it's Judge Henry Friendly. And Judge Friendly is one of the people, though he doesn't know it, who inspired this project. Our Office of the Chairman work has become so well respected that sometimes Congress, always on a bipartisan basis, assigns us reports to prepare. We released 2 such reports this year. The first, written in partnership with the National Academy of Public Administration, addresses the Social Security Administration's representative payee program, under which SSA appoints a representative to manage payments made to beneficiaries who, for disability or otherwise, cannot do so themselves. Our report focuses on institutional and legal barriers to the exchange of information between SSA and state entities that could help SSA better assess the suitability of prospective or existing representatives who may have served or applied to be state court-appointed guardians. The report will surely inform ongoing oversight of the representative payee program. The second of the congressionally required reports identifies all fiscal year 2019 fee awards against federal agencies under the Equal Access to Justice Act, or EJA, which provides for fee awards to certain private parties when they prevail against agencies in both formal agency adjudications and federal court litigation. Congress has said that it will use the report and an accompanying database on our website, both of which will be updated annually, to assess whether EJA is working as it was intended. I must pause here to thank federal agencies for responding so generously to our call for data. The response rate well exceeded 90%. Few agencies get that result, even with the help of a statutory mandate. And I must thank our attorney advisor, Bobby Ochoa, for managing this project so adroitly. The last thing I'll mention is that despite the pandemic, we were able to co-sponsor 3 well-attended public symposiums this year. The first with GW Law School on national injunctions, the second with the Georgetown Institute for Technology, Law, and Policy on artificial intelligence, and the third with the Gray Center at George Mason and the Center for Progressive Reform on agency adjudication. Over a dozen ACUS members joined other experts in speaking at these symposiums. They included our council member, Ron Cass, and in one of his last appearances, Judge Williams. In reviewing the foregoing activities of the chairman's office, I have sacrificed depth for breadth. Those of you who want additional information and to read the materials I've mentioned can find them on our website. Now would be a good time to invite you to sign up on our website to receive alerts about our activities. You have a lot of choices as to what and how much information to receive. Before we turn to business, I'll address one final topic. One of the most important functions of the chairman's office is to see to it that as far as our limited resources allow, ACUS's recommendations are implemented. I'll highlight 4 recent successes on this front. First, the Judicial Conference of the United States has noticed for public comment after 3 full years of debate, proposed amendments to the Federal Rules of Civil Procedure governing judicial review of Social Security decisions in federal courts. It was Recommendation 2016-3, Special Rules for Social Security Litigation in District Court, that prompted the Judicial Conference to propose these important amendments. Agency recruitment and selection of administrative law judges. No insider word of mouth hiring. Agencies should recruit so as to receive an optimal and broad pool of candidates. Third, agencies continue to post guidance documents on their websites in compliance with recent executive orders that align with 3 ACUS recommendations on guidance. Many such postings, moreover, reflect the best practices ACUS offered in Recommendation 2019-3, Public Availability of Agency Guidance. Tomorrow, Paul Ray, the Administrator of the Office of Information and Regulatory Affairs, OIRA, will have more to say about the quality and influence of ACUS's work on guidance. And fourth, the recent Executive Order 13960, promoting trustworthy artificial intelligence in the federal government, implements key recommendations related to privacy and transparency reflected in the 2 AI reports I've already mentioned. Of course, I refer to the implementation of the recommendations in the report and not the implementations of the statement that the Assembly will debate tomorrow. Now we'll turn to the rules for debating and voting, and then the first recommendation. The privilege of debates extends to all ACUS members. That includes ACUS's approximately 100 voting members who together constitute the Assembly and our non-voting members. The voting members are all members of the Council, government members, and public members. The non-voting members are all senior fellows, liaison representatives, and special counsels. Only voting members may move an amendment or vote. This year's virtual plenary session is, of course, different from all 72 that preceded it. Let's hope it will be the only one of its kind. As with any virtual event, we may encounter some hiccups along the way. Please be patient with ACUS staff and each other, as I will try very hard to be myself. ACUS staff members Jennifer Alvarez and Nathan Tomaso are on hand to help with any technical problems. For information on contacting them, please see the document you received titled Instructions for Participants. Those instructions also explain the mechanics and debating of voting in Zoom. I'll review them briefly now. For each recommendation, we'll start with the managers and council amendments, followed by the pre-submitted amendments. Only then will we consider amendments from the floor, which I hope will be in few in number, consistent with the membership's recent amendment to our bylaws. If you seek recognition, please send a short chat message in Zoom. Make sure the message is sent to everyone, not just the host only or a fellow participant. Include the reason you seek recognition without any lengthy explanation. Please do not use the chat function to engage in substantive discussions. You're all muted by default to avoid audio interference. When I recognize you, our event contractor will send you a message in Zoom requesting that you unmute yourself. Once you've done so, please begin by speaking. Initial votes will be taken by yeas and nays unless we can dispose of a matter by unanimous consent, which I intend to do as much as possible. If you object to something for which I am requesting unanimous consent, please send a chat message that says, I object. When I call for a voice vote, you'll receive a message in Zoom asking you to unmute yourself. Only voting members should click unmute. When prompted, you should say yay or nay. If the voice vote is inconclusive, I'll ask for a show of hands. Voting members should then turn on their cameras. Voting members in favor of the motion should then hold up a sheet of paper. They should keep it raised until I say that staff has determined the result of the vote. Now we'll turn to some initial procedural business. The first is approval of the minutes of the 72nd plenary session, which you'll find in your packets. Is there any objection to their approval? Without objection, they're approved. The next item is the adoption of our resolution on the order of business, which is also in your packets. It provides for 90 minutes of debate on each recommendation, which can be extended for an additional 30 minutes by majority vote. It also provides that pre-submitted amendments will be considered before any others. Your packet contains all the pre-submitted amendments. Is there any objection to the approval of the resolution? Without objection, it is approved. We'll now turn to the recommendations on the agenda this morning. Before doing so, I'd like to thank our members, staff, committee chairs, and especially our consultants for working so hard to get these recommendations done and done so well under the trying circumstances created by the pandemic. The agenda includes 6 committee proposed recommendations and 1 statement. After introducing each, I'll turn to the consultant and committee chair for brief remarks. Then we'll consider the manager's amendment. These consist of stylistic changes, most from members, some from staff, that I expect can be adopted by unanimous consent. General debate, if any is requested, will follow. We'll then consider in the following order: council amendments, pre-submitted member amendments, and any floor amendments that may be offered. You'll find in your packets each recommendation in both clean and red line form. The clean version represents the recommendation without any amendments. The red line version reflects all amendments. We'll show each amendment on the screen. Are we ready now to turn to the first recommendation? Do we have our consultants ready? Well, our consultant is to my right, Todd Rubin. And do we have the committee chair, Connor Rosso, ready as well?
I'm here, Matt.
Okay, thank you, Connor. This recommendation, Rules on Rulemaking, comes from the Committee on Regulation, I wish to thank our committee chair, Connor Rosso, for presiding over the committee proceedings, and our in-house researcher, Todd Rubin, for his excellent research and the set of materials that he assembled for this recommendation. We'll first hear from Todd on his research memorandum and accompanying materials, and then Connor on the committee's work. And before turning it over to Todd, I would request that in light of the amendments that have been offered both by the council and senior fellow Ron Levin, that Connor give some attention to the following questions as they came up during the committee proceedings. And those questions are: what kind of rule under APA Argo is a rule on rulemaking? Is it binding? And if so, in what respect? Should agencies disclaim bindingness in their rules on rulemakings, and what effect do or should such disclaimers have? Those are all large questions, I realize, but they were discussed in the committee meeting, and they certainly figure prominently with respect to the amendments we have. So I hope Connor will say a few words with respect to those questions, and of course address any other matters that he may wish to address. With that, let me turn it over to Todd.
Thank you, Matt. So my research for this project proceeded in 2 phases. One was a discovery phase in which the purpose was to uncover rules on rulemakings across agencies. And second was a policy considerations phase. phase, where I sought to uncover the key policy considerations underlying rules on rulemaking. So in the discovery phase, my sources primarily were the ECFR and agency websites. I uncovered 27 agency-styled rules that set forth the agency's rulemaking process, which I called rules on rulemakings. I examined their content and derived the most common topics covered in these documents, which appear in the appendix to the proposed recommendation. Combined across agencies, rules on rulemakings cover all phases of the rulemaking process, including petitions for rulemaking, OIRA review, and retrospective analysis. Some agency rules on rulemakings are very narrow, for example, only covering the process for petitioning. Some are nearly all-encompassing, covering everything from internal review to retrospective review. I also observed that rules on rulemakings often combine provisions that are only directed at agency officials with those that are directed at the public. For example, a rule provision that is directed only at agency officials might state, rule writers shall send all drafts of rules to the Office of General Counsel and the Office of Economic Policy for legal and economic review. A rule that is directed at the public might state all petitions for rulemakings must be accompanied by your name and be emailed to X official. I also looked for disclaimer language within these rules. 5 of the 27 that I uncovered state that the rule does not confer any substantive or procedural rights or benefits. I then stepped back and tried to see what were the main hallmarks of rules on rulemakings. What were their distinguishing features? 1, they confer authority within the agency. Agency employees are expected to adhere to the procedures, and if they want to deviate from them, higher level officials must authorize such a deviation. Secondly, they don't simply summarize or restate the requirements of rulemaking statutes, they go beyond these minima. And finally, agencies disseminate them publicly rather than just internally. In the policy considerations phase, my goal was to figure out the policy considerations. So the sources I used here were interviews with experts, many of whom are watching this now, and a review of the literature, all of which is in the memorandum. I also conducted a roundtable discussion in March of 2020, which consisted of congressional officials, executive branch officials, and academic experts. Key policy considerations that emerged from this research were first, accountability. By issuing a rule on rulemakings, an agency's leadership has weighed in on the policies that the agency will follow in conducting rulemaking. Transparency. By posting these materials on their websites, making them searchable and indexed, and possibly publishing them in the Federal Register and CFR, they become very widely publicly available and transparent. And finally, efficiency. When the agency has its rulemaking procedures in one place, it saves the public time. Instead of having to file a FOIA request to figure out what the agency's procedures are, they can go on the website or on the CFR and find them in one swoop. So that was the summary of my research, and I look forward to your questions and comments and discussion on the recommendation.
Connor, you're recognized.
Oh, well, thank you very much. And thank you, Todd, for doing such a thorough report, and especially for your hard work in drafting the recommendation and then pushing it along for response to committee discussion and debate. So thank you very much for your hard work. I also want to thank the committee, which put in 3 long and tough days on the GoToMeeting platform in working through this and improving this greatly. And I want to say these are very much committee consensus recommendations. And I'll sort of address a few of the issues that Matt had mentioned, as well as just a few other points from the committee's deliberations. And this is my sense of the committee's deliberations. Todd had just briefly outlined some of the policy considerations that we think inform agency decisions on rules making. And I would like to say that the committee had broad agreement with those policy considerations, those 4 or 5 policy considerations, and thought that was a helpful framework, a helpful basis from which to start thinking about this problem. So that's the first point. The second point is that the committee reached a consensus on the types of things that might go in rules on rulemaking. And there's an extensive list of those items, ideas in the appendix. The committee intentionally, very intentionally, did not say that the rules on rulemaking should include X, Y, Z in recognition of different agency circumstances that exist. So really the idea, as often happens in ACUS, is to give an agency a menu of options, but not to be prescriptive. Third point is that the committee viewed this as a great opportunity to build on a lot of the recent and current work ACUS has done on making agency materials accessible to the public, particularly on agency websites in the world we live in, making agency websites easy to access, use accessible language, and the committee views rules on rulemaking as an important part of that broader ACUS project. So I would delve into the issues that Matt had mentioned. If I wanted to just step back a little bit, I think the committee's goal is to broadly to balance two important considerations. The first consideration is a desire to encourage agencies to issue rules on rulemaking. So there's no requirement, legal requirement generally speaking, that they do so. And so we think that there are a lot of benefits to rules on rulemaking, and so we want to encourage those. And in doing so, we have to be cognizant of discouraging agencies from not issuing these rules due to fear of limiting their own discretion. And so we discussed how agencies may be reluctant to issue rules that they feel will limit their discretion down the road, perhaps in unanticipated ways. And so the recommendation includes 2 points on this sort of trade-off. One is that the recommendation notes that rules on rulemaking can, while we generally want them to be followed in the ordinary course, they can grant higher level agency officials authorization to deviate from rules on rulemaking when appropriate. So agencies, while binding on the lower level folks, the agency leadership can authorize deviation in appropriate circumstances. The second question, and one I suspect we'll spend some time on and we've had some amendments on, is what should the recommendations say on the extent to which rules on rulemaking may be enforceable against an agency in court? And so of course, this is sort of what a lot of people have in mind when they mean binding, not everybody. The word binding gets tricky. And so what the committee had attempted to do was to note, and Todd's great research uncovered this, that a number of agencies included kind of a standard disclaimer on this issue that would be directed both to the public and to a court. And Department of Transportation had helpfully noted that their recent rules, which have gotten some attention, include one of these disclaimers. But other agencies have not included such a disclaimer. So we note this. And I think some folks have reacted to some of the wording in this recommendation, especially the words "may wish." And so I think it's consistent with the committee's discussions to entertain amendments to just sort of clarify the point that an agency can give its views, but ACUS is not speaking to what a court should do in ACUS's view. We're not giving guidance to what a court should do with these disclaimers. And so need some amendments on that language, helpful potential amendments. And now I promise my fifth and final point is this. We also spent a good chunk of our first meeting getting bogged down in some doctrinal questions that I think have produced a lot of confusing and conflicting case law. And I would encourage us not to go down these roads today. One is, should the recommendation encourage agencies to issue their rules on rulemaking as legislative rules? And I know there's understandably a lot of interest in that question. I would note ACUS has previously defined legislative rules to include both substantive and procedural rules, which I think tripped up some folks on the committee. And so I would recommend avoiding that question. I don't think it's critical to the guidance that we're trying to give agencies. And that was the committee's sense as we progressed through our meetings. And then the final point, and this is something that Professor Levin had asked about, which I agree with, is the committee intentionally avoided discussion about whether, in the case that an agency says its rules on rulemaking are a policy statement, what impact should that have on the court's consideration of whether or not the rules on rulemaking are properly characterized as a policy statement or if they should be a legislative rule? We do not intend to get into that issue. I don't think it's appropriate. And I think not getting into that issue is consistent with prior ACUS work. So with all of that in mind, I look forward to getting the conference's feedback on these recommendations, and I will turn it back over to Matt.
Thank you, Connor, and thank you, Todd. The first thing we'll do is review and vote on the manager's amendment. Is there any objection to the adoption of the manager's amendment? Without objection, the manager's amendment is adopted. I'd like to turn now to general discussion, and then we'll turn to the council amendment and Professor Levin's amendment, which are obviously closely related. Is there anyone who wishes to be recognized for general discussion? Surely somebody must. I'll give it a half a minute here.
Jack Biermann has something.
Jack Biermann is recognized. Jack?
Thank you, Matt. I don't understand the controversy about whether the procedural rules, whether these rules would be binding. And I'd like to hear a little more about the committee's discussion. I mean, and I also don't understand why they would be called rules of general statements of policies rather than rules of agency procedure, which are exempt from APA Section 553. It seems to me if an agency promulgates a procedural rule, then the agency is expected to follow that rule unless perhaps there's discretion baked into the rule itself. Like if the agency could put in its rule that, you know, if it gives notice in advance of a proceeding, it may follow some other procedure. But so I'd like to hear a little more about why this, it doesn't, I didn't understand why there was even a controversy about this, but maybe it's just my density, not something you guys didn't explain.
Connor, do you wish to respond to Jack?
Well, Jack, I think a lot of the committee uses binding with respect to binding on the agency itself, or at least lower level staff. So somebody like Peter Strauss is associated with that sense of binding. Others have the view of binding on the agency in court. And there's a lot of opposition to recommending that agencies make their rules on rulemaking binding in court. The idea being that agencies would provide additional fodder for their rules to be challenged, and they'd be reluctant to do so voluntarily. And by making a recommendation that these rules be procedural rules binding in court, we would be discouraging agencies from issuing rules on rulemaking to begin with. And that was not the intention of the recommendation. So that's the kind of high level sense I took. There were folks who argued that these should be binding for some of the reasons you said. But given the complexity of the rulemaking process, unanticipated circumstances, I think the prevailing view in the committee was that that may discourage agencies from issuing the rules altogether.
Jack, did you wish to say anything further on the point?
Well, I just think I would oppose the recommendation on that basis. If an agency promulgates a procedural rule, it ought to be binding on the agency, and that includes enforcement in court. Imagine if an agency says, for example, the agency will not read late comments. Comments that come in after the deadline will not be read. And then in the rulemaking, the agency reads late comments. It seems to me that that's just a basic rule of law issue. And they might as well not bother issuing the rules unless they issue something like a guidance and say in the rule itself, generally, here's how we intend to conduct our rulemakings, but you should consult the notice on each particular rule to see how the particular rulemaking is going to be conducted, which I could imagine saying something like that in a recommendation that, that the recommendation, the rules themselves are, if the agency doesn't want to be bound, they ought to say so, but you should consult a particular rule, but otherwise I really don't understand the point of the exercise. If it's just going to be completely at the discretion of the agency to not follow it.
Connor, any further response, or should I ask if any other members wish to be recognized as part of the general debate?
Well, I mean, I think the recommendation notes that these rules would be followed the normal course, absent authorization for deviation. And I would just also note a number of agencies do include disclaimers along the line of the Department of Transportation disclaimer in practice. And Todd Rubin could speak to that more fully, but a number of agencies have seen fit not to bind themselves in an attempt to retain discretion where it's necessary. So I think the recommendation is consistent with a lot of the agency practice that Todd Rubin uncovered.
Does anybody else seek recognition? Nina Mendelson is recognized.
So this is a question for Connor, but was there consideration given for the reasons that you mentioned to raising the visibility of doing policies on rulemaking through general policy statements rather than calling them rules on rulemaking, which do carry a connotation of a legislative rule?
Well, yes, we did consider that thoroughly. We originally had in the first draft, a sort of a dichotomy between what we called explainers and between binding rules on rulemaking. And I think the committee was reluctant to go down this road. Partly it got unwieldy in trying to think about what would go in what bucket, if we could say anything about that. And Todd Rubin may have more thoughts on this, but also I think some folks thought that sort of defining what an explainer was challenging, actually, because there are many forms of explainers. And so it seemed more usable for the agencies to make recommendations with respect to rules on rulemaking, which could take different forms. And I would lastly note that the recommendation does have a nod toward explainers outside of the, this is number 4, should explain recommendation 4. It does have a nod toward explainers as well that are outside the rules on rulemaking. But Todd, you may have additional thoughts on this one.
Todd, do you have anything to add?
One other thing, I guess the only other thing I would add is in my research, these rules were styled in different ways. So some very much appear to be what the literature and some case law refers to as legislative rules, and some are what might be characterized as policy statements. And I think the way the recommendation turned out was not to endorse either one or really to belabor the point as to distinguishing them. It was to acknowledge the fact that the recommendation ends up, I think, contemplating the fact that agencies may issue these procedures through what they would call a policy statement or through what they would call a legislative rule. And I don't think it comes down in favor of one or the other.
Thank you. That's something that a lot of our agency reps echoed Todd on. So thank you for that reminder, Todd.
Nina, anything further from you?
No, I'll just say briefly, I have some concern that this recommendation might point agencies in the direction of kind of a new squishy category of agency action, a rule that doesn't fit our norms for legislative rules. Some language in the recommendation speaks in terms of agencies acting authoritatively, creating commitments. The title of the recommendation says rule. Those point in the direction of, kind of our conventional notions of what is a rule under the APA, including, as Jack suggested, a procedural rule that we would see as binding. Meanwhile, there's this other signaling, including in that footnote 7 and in Connor's comments, that we don't want to discourage agencies from doing this because they're worried they'll end up in court over it. And I feel like this is a tension that isn't fully resolved or clearly resolved in the recommendation.
Thank you very much, Nina. We'll turn to the amendments now, and in particular, the Council Amendment and the Levin Amendment, which are closely related. The Council Amendment would strike the language appearing on page 3, lines 45 through 48, which reads, as paragraph 7 below provides, an agency that does not wish to be bound by its rule on rulemaking may wish to include a provision in its rule on rulemakings stating that such rules do not create any substantive or procedural rights or benefits. The council has an accompanying amendment on page 5, which would strike the corresponding paragraph 7 in the recommendation. The council has provided a written explanation there. The council has also added to the preamble a new footnote 6, which reads, and it is in your packets, but let me read it. Some rules on rulemaking include a statement that they do not create any substantive or procedural rights or benefits. This recommendation does not address whether such disclaimers should be included or what legal effect they have on judicial review. These questions cannot be answered in isolation from the broader question of when a rule on rulemaking is judicially enforceable. What I would like to do now is ask, I think the council amendment, as the lawyers say, speaks for itself. If there are any members of the council, however, who wish to express, wish to be heard on the council amendment or any related subject, please speak up now and I will recognize you first. Ron Cass is recognized.
Thank you. I just wanted to say that I think this is a very important amendment. I don't think it undercuts the project that the consultant and committee have undertaken, but I think it does make clear that we are not taking a position on enforceability here. We're not recommending that agencies provide anything in their rules or their statements that suggests that these rules are not enforceable, nor do we encourage agencies to adopt language saying that they don't intend them to be enforceable. But we do this without getting into the controversy of what the nature of the legal rule is, which is a matter for the courts. And I think we should, I support the council amendments on both the statement here in the footnote and the elimination of recommendation number 7.
Thank you, Ron. Are there any other council members who wish to be recognized? Give it 10 seconds and then I will move on. I would certainly recognize any, there appear not to be any council members who seek recognition at this time. I'm certainly happy to recognize them if they have comments that they wish to add later. Before I'd like to recognize Ron, our other Ron. I think we have 2 Rons. Our other Ron Levin, who has offered an amendment which relates to the same subject of the council amendment. And I'd like Ron to identify his amendment and explain the basis for it. Before doing that, though, I'd just like to turn to Todd for 1 second, and I may be asking you to repeat something that you have already said, but could you tell us the prevalence of disclaimers of the sort we're talking about here in the rules on rules that are appended to the memo that you wrote?
Yeah, so of the 27 rules on rulemakings that I had covered, 5 have these disclaimers and they're all worded similarly. So they say the rule does not confer any substantive or procedural rights or benefits.
Ron Levin, are you ready?
Yes. Matt, I'll take your advice about how to proceed here. Just to be very brief, I think the council's amendment would be my next choice after my own. So one way to approach it would be to see if the council amendment passes, then consider mine if you want. Otherwise, I will give a full spiel about the rationale for mine that you can take up, so we can take up both at the same time. It sounded like you had in mind the latter. Shall I do that?
Why don't you give a brief explanation, and then what I think we'll do is take a vote on the council amendment.
Okay. Well, so I'm not a member of the committee. I didn't participate in this process, but when I saw the proposed recommendation, I did think that paragraph 7 as proposed went too far. My thoughts are similar to those of Jack Biermann, that there certainly are some rules pertaining to rulemaking that we just naturally expect will be enforceable. He mentioned the example of reply comments, but you also have minimum comment lengths, ex parte contact rules. All those are things which are there for the benefit of the public, and we expect that those are adopted, and an agency shouldn't be able to say, we just don't want it to be enforced. The Carty doctrine provides that in many cases procedural rules are enforceable. However, there are exceptions to ACARDI, and what I tried to do is to come up with a compromise or intermediate position, which would single out some areas where it is not uncommon for rules to be unenforceable and for the agency to maybe be suggested they may want to say that with regard to those rules, which are primarily ones of internal management. And it's not at all uncommon for some provisions to be adopted with no expectation of being judicially enforceable. And I gave the example of executive orders, which do say frequently, this is a matter of internal management, and therefore it creates no substantive rights enforceable in court. And that has been upheld in court in the case of Executive Order 12866. So it builds on that, but it does not actually say that the sort of disclaimer language that I am suggesting would work. It suggests you may want to put it there to see how far it travels. Just let's be clear at what I'm proposing here. Do you see the text? It would say that the agency may want, let's get the language that I'm proposing, insofar for the recommendation proper, insofar as an agency considers some or all provisions in a rule or on rulemaking to have been adopted for internal management reasons, making them inappropriate for private enforcement, it should consider including in the rule on rulemaking a statement that such rules or provisions do not create any substantive or procedural rights and benefits. So in contrast to the committee proposal, it would apply to only some rules on rulemaking. And it would expect the agency to give a little thought to which ones can be properly described as managerial and not ones that create rights for the public. And if the agency has given it some thought and put in a representation as part of its rule, a court might give weight to that. Doesn't say it would, but you might want to give it a try. This seemed to be similar to the recommendation on severability we adopted a few years ago, 2018-2. We did not try to specify when regulations are severable, parts of regulations are severable, but we said, here are conditions in which you might increase the chance that it would come out the way you want it to come out. And here too, I don't think that the agency by its say-so can just exempt a rule from enforcement, but it may be able to say, here's the kind that under some significant precedent, maybe you want to hold unenforceable. That might do the agency some good. So one reason to have this sort of disclaimer provision is that it might encourage agencies to give it a try with respect to the subset of rules where it's appropriate. And the other advantage is maybe this kind of language would very subtly suggest to some agencies that they have gone overboard in the disclaimers they have adopted. It doesn't directly say that, but it sort of suggests that if they have adopted provisions that go beyond internal management and really relate directly to rights of parties, that maybe what they're claiming is not a good idea, and maybe the conference can suggest that. So not taking a position on the legal issue, but providing some language by which an agency might steer that resolution a little bit. That's the rationale for this. And I think it might work as a compromise between what the committee originally wanted and the more cautious approach of saying, maybe we better not get into this, although I have some sympathy for the latter.
Thank you, Ron. We'll hear from John Siegel is recognized. And then Ron Cass will be recognized.
I think I have a fair amount of sympathy for what Jack Biermann and Nina Mendelsohn said, that normally if an agency adopts a rule for itself, that rule binds the agency, even if the agency didn't have to adopt the rule in the first place. And yet I understand what the council and Ron Levin are suggesting, and I understand that maybe in some circumstances agencies wouldn't like to not constrain themselves in a way that make their rules more open to judicial review. But I guess my main comment is, in that circumstance, wouldn't it be more appropriate for the agency, as Jack Biermann suggested, to build the flexibility into the rule rather than adopt the rule and have a comment saying, but it's not enforceable? So for example, if an agency adopted a rule that said, we think no rule should be issued by notice and comment with a comment period of less than 90 days. So our rule is we will always have a comment period of at least 90 days. But they anticipate that something might come up and they might need to get a rule out faster. So they put a note in saying, but this isn't judicially enforceable. Wouldn't it be superior to recommend that the agency say, we have an aspirational goal of allowing at least 90 days for comments, but we recognize that in some emergency situations, we might have to have a shorter comment period. So instead of saying agencies might want to consider adopting a note saying this is not enforceable, this doesn't create an enforceable rights, wouldn't it be superior to say the agency should consider putting in a note saying this is our aspirational goal and this is what we will usually do, but in appropriate circumstances we might have to depart from it?
Thank you, John. Before I do want to go back to Ron Cass, but before doing that, I'd like to recognize Nina Mendelson once more, and then Don Elliott. Nina?
I'll be quick. I completely agree with what Jonathan Siegel just said. I just want to add, I think the question of whether a boilerplate disclaimer like that could be effective is a really difficult one. It might raise the question of whether an agency could, through a rule, commit something to agency discretion under Section 701 of the APA. That seems like an extraordinarily difficult question. Meanwhile, we want recommendations to be useful guidance, and if we suggest that agencies should consider a disclaimer, that might signal to them that ACUS thinks this strategy could potentially be effective. So with all due respect for Ron Levin and his continued efforts to broker compromises, which I appreciate, I think it would be great if we just went ahead with the council amendment and lowered the profile of this particular suggestion.
Thank you, Nina. I'm going to let Connor Rosso jump in real briefly here.
I'll be very brief. I just want to be clear. We did not mean to recommend what a court should do or should not do with these disclaimers. And I concede the word wish is confusing. And so I think that may be causing part of the problem, but the committee did not intend to tell the courts how to handle these disclaimers. And so we should clarify the language. And my sense, briefly, since a couple of folks asked, is that the Levin Amendment is very helpful and closer to the committee's view of this issue. And I also like that the Levin Amendment continues to address the issue in the recommendation itself. But I don't think this is a critical issue, and the council amendment, I think, also would work with the spirit of the committee's discussions. And then last thing to Professor Siegel, I understand the point about building in flexibility. I will say that agencies sometimes worry about issues they don't foresee the need to build in flexibility. Things come up, and the agency, when it wrote these rules on rulemaking years ago, did not anticipate the need to build flexibility on that issue. And so agencies may be reluctant to bind themselves on issues that they can't foresee the need to build flexibility on. Thank you.
Let's turn to Don Elliott. Don Elliott is recognized. He has a response to the council amendment and or the Levin Amendment.
Thank
Don?
you. Yes, can you hear me?
Yes.
Okay, good, thank you. So I was not a member of the committee, although I did go to a couple of their meetings and participate in them. I took a strong position, unsuccessfully, that ACUS should recommend that courts give deference to the agency's characterization. So I don't want to get involved in that issue, and I take no position on the council amendment. I don't have a vote anyway, but I would suggest that the Levin Amendment might better fit into the preamble as sort of background, because I think Ron makes good points about the potential analogy, but I think it's not really appropriate since it doesn't really make anything to do with the recommendation. So I would suggest we might consider, and I would hope that Ron might think of this as a friendly amendment, that we might consider moving the language of the Levin Amendment into the preamble.
Ron Levin.
I think it is generously meant, but not friendly in the legal sense.
All right, so we'll turn to Ron Cass has been waiting patiently. I recognize Ron Cass now.
I just wanted to say, as a matter of ACUS practice, I think we avoid telling courts how to come out on legal issues. And I think while a lot of what's been said is both helpful and thoughtful, I would think the council amendment better fits our practice and drops this issue from the recommendation. It doesn't presume to take a position on what court should hold on this. And I think if we wanted to do that, that would be something we would have to do through a process that focused more clearly and more extensively on that particular issue.
Thank you, Ron. We do. It is infrequently that the ACUS makes recommendations to the courts on doctrinal matters. So you're right in that respect. Are there any other members who of the council or otherwise who would like to speak on the council amendment or Don or Ron Levin's alternative? I see that William Funk would like to be recognized, and I recognize him now.
Thanks, Matt. Can you hear me?
We can hear you.
Okay. I'm thinking, as having been a rule writer for an agency and thinking about whether I would recommend to the General Counsel that we adopt a rule on rulemaking in light of the recommendation. And it would be critical to me to know whether or not, or to have a strong feeling whether or not it would be judicially enforceable. We can give management directives without going through the Federal Register or the Code of Federal Regulations and being transparent. The idea here is to be transparent and yet retain the same sort of flexibility one would have, I think, through an internal management directive. And so in that regard, I think some sort of indication, whether it's the Levin Amendment or the original recommendation, that holds out the possibility, if not the recommendation or the at least probability, that courts would respect a determination that this was intended as a management directive rather than as a public rule in the sense, binding rule in the sense that we think binding, including protecting the public and judicially enforceable means. So I think it's important to get something like the Levin Amendment in there.
Ron, you're recognized briefly. Ron Levin.
Okay, I'll just respond quickly to a couple of points that people have made. First, in response to Nina, I do understand the real risk that things could get out of hand. But right now we have a state of affairs in which there are provisions of this kind or comparable that do go unenforced. The executive orders are examples, and I think everybody's familiar with a panoply of executive orders that are regarded as internally important, not optional, not, you're definitely supposed to do it, but there's no expectation that courts would apply it. I included a see also site to the blackball case. I didn't want to elevate it to anything more than a see also, but there's some precedent for this. But can we readily define what goes into the category of internal management? Not offhand, nor do I think we should try. I think if we put this out there in the manner that Bill described, there'd have to be some experimentation. There'd have to be some trial and error. Sometimes an agency would go too far with that characterization. I think this is a ripe territory for law review writers and bloggers and the like to explore. I think it's appropriate for us to be very general about it. But to give that hint, I think that's constructive for the reasons that I mentioned before. In the first place, to give agencies a little encouragement to adopt rules that are legitimately internal management by suggesting that it might be worth their time to try to put in a disclaimer with respect to them. And secondly, to discourage agencies from claiming too much with regard to disclaimers. The other thing I will say on this technical point of guidance versus legislative rules, like Connor, I agree that that is something we shouldn't get bogged down on. But to respond to what Jack said, I think there's no antithesis between something being a procedural rule and being a general statement of policy. Although it could be either. We're not talking here about whether notice of comment is required. It normally wouldn't be because of the procedural rule exemption. But we're distinguishing, well, the question is, do we want to distinguish between rules that the agency regards as legislative rules, as rules that it has no flexibility about, versus rules that it considers guidance in the sense that they're willing to waive it, to give people a chance to talk them out of it. If it's a legislative rule, they say, look, we've committed ourselves to this, don't even ask us to depart. If it is guidance pursuant to the conference recommendations a few years ago, they should at least give someone a chance to talk them out of it. There'll be times where an agency wants to be bound that way, other times when it doesn't. It doesn't really matter for purposes of what I'm proposing, which is they're being able to say whether or not we would consider departing from it if asked. We believe that this is something that is internal management, and for that reason is one that the court should stay out of. Just as with executive orders, I don't think that, 12866 is not thought of as optional. You can't ask them not to comply with it. But nevertheless, it is considered to be outside the court's domain, and that is the frame in which I think this should be viewed.
Jennifer No is recognized. Jennifer?
Yeah, so I think my comment suggestion doesn't necessarily bear on the council amendment versus the Ron Levin amendment debate, but I did want to, but it still goes to the substantive question of how can we give agencies a little bit more guidance on how to avoid the possibility that their so-called rule would be enforced in court. I want to amplify Jonathan Siegel's suggestion because I think it was a good one. And I didn't think that Connor's response was necessarily definitive. And in the sense that, why don't we suggest something like the agency's adopting language in its rule to the effect of, something like, when practical and feasible, these are the procedures that we will follow. And therefore baking discretion into the rule such that if a court were to, for perhaps to Nina's point, disregard the disclaimer and enforce the rule, the agency could say, well, look, we didn't bind ourselves. We have discretion baked in. And for this practical reason, we didn't follow the procedure in this case.
Jennifer, that's a very good point. It may come up actually in one of our other recommendations. I think that point stands largely independent of the council amendment and Ron's alternative. And John, before we turn to a vote on the council amendment, we're going to just hear briefly from John Duffy, and that will be it by way of further debate on the council amendment.
Thank you for recognizing me. I just wanted to say that I support the council amendment rather than the Levin amendment, because I think drawing an analogy to executive orders is, I think, a little dangerous because, of course, the president and the executive office of the president is outside the scope of the APA. So I think that many of the arguments that rules have to be binding don't apply, many of the legal rule arguments, I think. So I think actually drawing that analogy, which I think is intellectually, I understand the argument, but I think it actually cuts in favor of the council's approach rather than the Levin approach. Thanks.
Does anybody on the council wish to be heard further on the council amendment, whether Ron Cass or otherwise? All right, if not, we're going to take our first voice vote this morning. Reeve or someone, I understand that we're going to be, that everyone will receive a message indicate in Zoom asking that they unmute themselves. Is that correct? And has that message been sent? And should I give a minute or two for everyone to unmute themselves, which I suspect could be a challenge? Pardon? Everyone's unmuted. Well, that's terrific. All those in favor of the council amendment, please say yay.
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 Nay.
Opposed, nay.
Nay.
As Reeve, would you agree with me that the yeas have it? All right, the yeas have it and the council amendment is adopted. Hold on, Jennifer, and hold on, Ron. Let's work through the remainder, and hold on, Jeff Lubbers, who has a suggestion on the title. But let's move now to the next pre-submitted amendment, which I believe comes from is it Jack Biermann, Reeve? Jack Biermann, you have an amendment on page 8 of the red line, and that's to the appendix. I'll recognize you now to speak on your amendment, to explain and to identify and then explain your amendment. Jack, please.
Okay, great, thanks. It's a little bit hard to do this with all the different versions flying around, so I'm going to do my best to get. So if we look at the original, most of these are just editing suggestions.
Wait, Jack, what versions are flying around? There are two. There's a red line.
Right. So I was looking. I keyed mine to the original version that was on the website for the meeting. Okay. And so I guess what I need to do is look at the red line, which you have up on the screen now. So can you take me to line 16? Most of these are simple editing. One of them is a little bit substantive. So if you can you get to line 16 on this document that's being shared? Okay.
What is your pre-submitted? What are you referring to, Jack?
Okay, so that one is already in there. So on line 16, I suggested changing not to more than, which is already in there.
Jack, that's already been adopted as a manager's amendment.
Oh, okay. I'm sorry.
So you should proceed directly to, I believe, your amendment on the appendix. Is that correct? Okay.
Okay, line 105. I suggested adding ex parte communications, and that's what you've had it on. You have it there on line 102 under number 3. Is that now, that hasn't been amended, right? Is it? It hasn't been adopted, has it? No, that's my amendment. So I just thought that a policy on ex parte context would be something we would think of in a rule on rulemaking. It's a big, important issue in rulemaking, and I don't think we say anything one way or the other, but they ought to say what they think. And then adding number 4, handling external merits communications not filed as comments, because that's something that was mentioned, I believe, in the preamble, but didn't make it into the, or it mentioned in some other place and didn't make it into the body of it. And then number 5, handling interagency, and other internal executive branch merits communications not filed as comments, because that's something that also comes up, is what do you do with communications that come in from other agencies or from the office of the president and such. So those are all on the same theme. They're just matters that I think agencies ought to consider when they're formulating these rules on rulemaking.
All right. So your amendment would add 3 categories: policies on ex parte contacts, handling external merits communications not filed as comments, and handling interagency, and other internal executive branch merits communications not filed as comments. Is that right?
Right, exactly. Those 3 that are in blue there on the board.
All right, let me turn to Connor, the committee chair, to see if he has any comments on Jack's amendments. I don't recall if these particular items were discussed, and if they were discussed, what resolution was reached. So let me just turn to Connor first to see if he has any comments here.
No, we did discuss several of these, and we did a lot of editing, and I think including them is consistent with the committee's consideration of this issue, and I would personally support it.
Does anybody else wish to be heard on the what I'll refer to as the Biermann Amendment? Reeve, there's a proposed amendment from Jack Biermann on page 9 of the red line. Is that separate from the?
Now, that's part of the same thing that he's striking external merits communication comments at B. And I believe he's basically moving, Jack, correct me if I'm wrong, to B as being ex parte comment.
Okay.
If I could just elaborate, that was just, I thought, in the wrong place, but it's repeated in my amendment and deleted here.
All right, so we'll just treat we'll treat yours as we'll treat these various items in yours as a single amendment. I'd like to recognize Kent Barnett now, who has a question.
Thank you. Thanks, Matt. The question is for Jack on the line that says handling intra-agency merits communications not filed as comments. What did you have in mind there? Because that strikes me as problematic. That would essentially be any communication on the merits within the agency, from what I can tell, between any of the staff, lawyers just going back and forth about various issues. Is there something more specific that you're concerned about there?
Jack?
Oh, yeah, I was thinking of, for example, communication from one part of a department to an agency within that department. But I see, Kent, that is a red flag, and maybe the better idea would be to strike that and just leave it at interagency.
All right, so Jack, you're striking you're modifying your amendment to strike intra-agency. Is that correct?
Right. Yes, I think that's probably wise.
And Kent, are you happy with that?
Yes, that works for me. Thank you.
Connor Rosso, anything further on this Biermann Amendment?
No, I had sort of read that as stuff that would go into the administrative record, but I think you're right. It could lead to confusion, and when I read something into something that others don't, that's a bad sign. So I think it's a good suggestion.
Okay, Ron Cass has a question. Ron Cass is recognized. I didn't forget you, Ron Levin, by the way.
Yes, I do have a question, and this is for Jack. What is it that we're picking up in number 5 that isn't picked up in number 4 in your proposal?
Well, the answer is that in some analyses and cases in the case law, these are treated as separate issues. That is, external ex parte communications versus internal governmental ones. And so I thought it was important to pull that out because agencies may have different policies on those. So it's not, I mean, obviously it's not, you could call them all ex parte communications and just leave it all at number 3. But I think that intragovernmental, and then especially communications also from from the legislature and from the executive branch, those are treated differently from ex parte communications coming from outside. So that's why I identified them separately.
I would just I think that the issues connected with internal within the executive branch communications are complex and difficult, and I'm not sure that we've thought them through in the recommendation and the framing of this particular project in a way that I would feel comfortable trying to say something about that, and particularly to flag it separately from other sorts of comments to the agency. And I would be cautious that we're not stepping into something we haven't really researched and thought through significantly.
Jack, you want to listen to your dean or no?
Yeah, if I don't feel that strongly about it, but obviously the ex parte communications is a broad umbrella. So if other people other than my former dean think that, then I would be happy to. I would 90% of what I'm concerned with is just policies and ex parte context and moving the other thing to what I thought was the right place. The rest of it was, designed to really to provoke some discussion from the committee about whether they had thought about this and whether this was something they thought was a good idea. So I'm happy either way. I don't. If other people agree with Ron that that's too sticky of a wicket, also, then I'd be happy to just go with the first two and leave out the last one.
So your amendment as revised is going to read what exactly? Can we get that up on the screen and make sure we have it right?
So I guess I've consented to the revision. So it would just be add policies on ex parte context as number 3 and number 4, handling external merits communications not filed with comment.
We got it correctly, Todd?
Yeah, that's
Jeff Lovers is recognized for 30 seconds on this point.
Yes, I just point out that ACUS did do a recommendation on intragovernmental communications. It's recommendation 80-6. So we have treated that as a separate issue and made some recommendations about how agencies should handle that.
Okay. Is there any objection to the Biermann Amendment as amended?
Oh, I want to comment. Hello, this is Renee Landers.
Renee, hold on a sec, please. So I'm sorry. What do you wish to be recognized on?
On this very issue, I want to support Jack's original language with the striking of the intra-agency wording that.
So do you support what's on the screen?
I do. It's with the striking.
So why don't speak to the amendment as amended.
Amendment as amended.
Who recognized her?
I disagree with that because I thought that I support the original Biermann language with that one modification that we talked about earlier about the intra-agency reference, because I think the main point here is that agencies, if they're going to rely on anything in these communications anyway, they have to have some mechanism for acknowledging that they receive these comments. And so I think this just sort of focuses everyone's mind on the need to, have some policies about what kinds of communications are going to be, are going to be considered appropriate and useful in this process.
Jack, anything further on this in response to Renee?
I guess I like my the original proposal with this one slight modification, but I don't really feel strongly one way or the other. So it's really more up to the body, I guess. I mean, I don't know what more to say.
You tell us what. Yeah, Bobby, did you need something? Tell us how you want the Biermann Amendment to be phrased, and then we will take a vote on it.
Well, I don't want to. I guess maybe it's not worth the controversy that if policies on ex parte context would include everything that is in my that is in number what I had proposed as the new number 5 anyway. So I guess I'm going to recede on that based on Ron's comment, and so people can vote against it if they feel strongly, and then Renee can propose to revert to it. I guess. Or add it. Renee can propose to add it back later. I don't want to cause more of a stir than I already have.
So is the Biermann Amendment is as it reads on the screen, correct?
Yes.
Renee, you object to the Biermann Amendment? Renee Landers is recognized.
Thank you. I mean, I guess I will defer to Jack's characterization, because I guess I basically agree that he's right, that everything could be subsumed into these other 2 points. So, so that's fine.
Okay, thank you very much, Renee. That's the ACUS spirit. Is there any objection to Jack Biermann's amendment? Without objection, Jack Biermann's amendment as it appears on the screen is adopted. Reeve, there are no more pre-submitted amendments, correct? All right, so now what we're going to do is, Ron, you have asked about your amendment and how it will be considered. The question is whether you may not move an amendment, as I needn't tell you. The question is there a voting member of the conference who wishes to take up your cause?
Matt, I will move.
You will move the Levin amendment?
Yes.
As it appears on the screen?
Yes.
Okay. Levin amendment. Does anybody else wish to be heard on the Levin amendment before we take a vote on the Levin amendment?
Can you put it back on the screen?
Recommendations, you go down to number 7.
Yeah, let's put it up on the screen. I'm sorry. Let's get it up on the screen.
Go up further, go up further.
Up further. It's in the actual, it's in the right, further up.
Further.
No.
Agency should consider these.
We already handled it.
We have not handled the Levin amendment. Is that up? Is that correctly up on the screen? Should I read the Levin amendment? Ron Cass, do you wish to be recognized on this point? Ron Cass?
Yeah, I just wanted to, if I'm unmuted, I just
Ron
wanted to
Cass, you're
say,
recognized.
thank you. I would oppose the amendment with respect for the points it's making. I think that this is not something we should have in the recommendation at this point. I think that for the reasons we discussed earlier, this is something that deserves more serious attention and more consideration by the committee before we get to voting on it as language in the recommendation. And I think it is better for the conference not to be taking a position on the way these particular procedures ought to be treated in court at this point. So I will stop at that.
All right, even though it's now Connor's amendment, I'm just going to refer to it as the Levin amendment so as not to confuse everyone. We're going to take a voice vote on the Levin amendment. So everyone please unmute. Voting members, please unmute themselves. All those in favor of the Levin amendment, please say yay.
Yay.
Yay. All those opposed, nay.
Nay.
Nay. Nay.
Nay.
Pardon? It's about even. Should we resort to a show of hands vote? Okay, let's do that. This is on the Levin amendment.
There's a component of Levin's amendment that's in the preamble, right? Yeah. So.
Well, it's being treated as one amendment, correct?
I just want to make sure people know that.
Do you want me to read it? Would it be helpful if I read the Levin amendment? We identified the Levin amendment again. Or is it clear? Show the 11 amendment. It's on lines. Todd, why don't you identify it for us, please?
11 amendment appears what you see currently on lines 45 through 52, or 54 rather. And then
that's to the preamble.
That's the preamble. And then the second part of the same amendment is what appears under as paragraph 7 right now from lines 92 to 95.
So the 11 amendment includes the paragraph, the new paragraph in the preamble,
Correct.
plus a new paragraph 7.
Correct.
And that will be treated as a single,
Yes.
Amendment. Kai Feldblum is informing me that her video is not working. Can we hear you? Can we hear you, Kai? Kai Feldblum?
Yes, you can hear me.
What is your vote on the 11? What is your vote on the 11 amendment?
Let me just take another look at it and let other people do. Did you do your?
All right. We're going to take a show of hands vote.
No, I would.
Someone need to be unmuted. We're getting feedback here.
Everyone's unmuted right now, so they do the voice vote. You guys can do this. Almost every person's video is up.
Okay, and we have we have an additional member whose video is not working, and if it's close, I will ask for her vote. So we will take a, please turn on your cameras. I think you've already done. All those in favor of the Levin Amendment, please raise a sheet of paper and we will count the votes. And this might take us a few minutes to do, so just bear with us. All those against the Levin Amendment, please say nay. Or please hold up a piece of paper, excuse me. By how many?
13 to 26.
Okay, the Levin Amendment is not adopted, and I have accounted for I have accounted for those of you whose video is not working and have voted through the chat feature. So the Levin Amendment does not carry. Let me just maybe now is a good time to remind members that they do have the right to file separate statements to accompany any recommendation, and those separate statements will be published in the Federal Register along with the ACUS recommendation. Okay. Steve, is there anything left on are there any pre-submitted amendments left on this recommendation? Or have we dispensed with them all? Okay, I'm going to now recognize Jeff Lubbers, who I believe has a comment on the title of the recommendation. Jeff?
Yes, thank you. I'm going back now to Nina Mendelson's comment on the title. I think the term rules on rulemaking, while it's a catchy title, kind of adds too much formality to the idea. So I don't know what would be lost if we referred to them as statements on rulemaking. And I would amend the title. I know it's a little unwieldy, but agency statements to the public on their rulemaking practices. And then where we've got in the text where it talks about rules on rulemakings, we can substitute statements on rulemaking, because I think for the reasons that Nina suggested, that this will make these rules seem too formal and kind of chill the agency's willingness to follow the recommendation. And I can't make amendments, so that's just an idea. Someone else wants to.
Could you, was this, let me turn to Connor, actually. I have a vague recollection that this amendment or proposed title change was discussed in the committee. Is that correct?
Well, I did raise something. I don't exactly remember what I suggested at the committee, but I did make the point at the committee that the title was problematic.
And that's why I want to turn to Connor to ask if he recalls what committee consideration was given to the change of title and why.
My recollection is that this came up at the very first draft when we had created a stark dichotomy between rules on rulemaking that would be binding in the sense of in court versus explainers. And as I remember it, there was concern that half the recommendation was about the explainers, but the title was about rules on rulemaking. And so it was misleading. But then when we altered the approach and were less prescriptive about what the rules on rulemaking would say, we thought the title was appropriate. So that's my sense of where the committee kind of went on this. And I'm happy to speak more to the title, but I'll just stay with what the committee deliberations were for now.
Does any other member wish to be recognized with respect to Jeff's proposal on a title change? Is there a voting member who wishes to move an amendment to change the title? Chris Walker, did you have a comment?
Yeah,
Renee, you're raising your hand. Renee, just hold on one sec. Renee, are you raising your hand?
I was, but.
You got it. You have to seek. Chris Walker.
My quick reaction is while I understand the concerns that, perhaps it might maybe discourage some agencies. I mean, rules on rulemaking seems to be catchy, and it is kind of what people are calling it, over the last few years. So I'd be in favor of just keeping it short and simple and let the rest of the recommendation speak for itself.
Renee Landers.
Well, I guess I was just going, for the sake of other comedy, I was just going to move it so that people could consider Jeff's suggestion. Because I think he makes some good points about what kind of signal the title is sending.
Okay. Anna Shavers, did you have a, Anna Shavers, do you wish to be recognized?
No, I was just making a comment on the method of voting.
All right, we will address that separately at the break. I'd actually appreciate if everyone could refrain from making comments about voting protocols because it's distracting us on this end from recognizing people. We will look at that. We will consider it at the break. It was not a haphazardly made decision to do things as we're doing, but we will take another look at it at the break. So now we're back to, so what we have is we have the Landers Amendment to modify the title. Does anybody wish, now I see Nina Mendelson has an alternative suggestion. Nina, you're recognized.
So I think the goal of this amendment is to be a little clear about what the legal status of these statements might be and reduce the confusion. But the existing title is catchy. So the alternative I was going to put on the table for consideration might be something like rulemaking protocols, rulemaking practices. Again, I don't have the power to offer an amendment. I just make this in the nature of a comment.
Renee, do you wish to offer your amendment with or without modifications?
Sure. I like Nina's alternatives, and so let's see. You could, rules. Policies. Or rulemaking practices. I mean, I think the agency rulemaking practices.
All right. Kristen Hickman has a comment, and I'll recognize Kristen, and then we're going to proceed to a vote on the title. Kristen?
Sure. I think I prefer rules on rulemaking, but I will make the observation that agency statements to the public on their rulemaking practice is a little bit unclear as to what exactly their means. I think it should be agency statements to the public on agency rulemaking practices in order to be clearer.
That's fine with me.
Hold on, Jeff. Jack Biermann wishes to be recognized.
Yep. I think the title Rules on Rulemaking Practices would be the clearest, simplest, and change that would recognize Jeff's concerns. Rules on Rulemaking Practices. That would be my suggestion.
Renee, what is your preference on the title?
That would be fine. I had considered that one, so that would be fine with me.
Jeff, do you wish to be further heard on the title?
I think Nina's alternatives were a little closer to what I was thinking because Jack's still contains the word rule in the title.
Okay. So, Renee, what is your amendment? Because Jeff and Nina may not move an amendment, so you have to tell us what your amendment is if you want a title change.
Yeah, I understand. Agency statements, agency policies, agency rulemaking practices. I'm just going to go with agency rulemaking practices.
Okay, let's just have that on the. So the Landers Amendment is to change the title to agency rulemaking practices. Please unmute yourself. We'll take a voice vote because I won't ask unanimous consent on this one because I won't get it. All those in favor of the Landers Amendment, please say yay.
Yes.
Yay.
Yay.
Yay. All opposed, nay.
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 The nays have it. Yes, the nays have it, and the Landers Amendment is not adopted. Are there any other amendments on the recommendation from the floor?
Yeah, I got to buy some more. It's that Land Lake stuff, the richer stuff.
Could we just unmute Russell Wheeler, please? Are there any additional amendments from the floor on this recommendation? If not, we should proceed to a final vote, correct? All right, we will proceed to a final vote on this recommendation. We will do this by voice vote. Please unmute yourselves. All those in favor of adoption of the recommendation, please say yay.
Yay.
Yay. All those opposed, say nay.
Nay.
Nay. Nay. The yeas have it, and the recommendation is adopted. With my thanks to all of you, and especially Connor Rosso for chairing what was a challenging committee process. Thank you, Connor. With that, the next item on our agenda is a lunch break until 12:30, and so we'll resume at 12:30. And as I promised in the interim, the staff and I will discuss the voting protocols and be back with you on that when we resume at 12:30. Thank you very much. Good afternoon and welcome back from lunch. We'll proceed to the next recommendation. Before I do that, though, I do want to address the protocols. On the advice of our vendor and our staff, we are not going to make any changes to the voting protocols. We'll be happy to revisit the issue if we do this again virtually. The other thing is, I understand that some of you may not have heard my at least a portion of my opening remarks. Good for you. What I will do is, after the plenary session, I will circulate my opening remarks, the text of my opening remarks, and I will also include a list of the projects that are mentioned in the remarks and some additional ones, along with links to the pages on our website where you can learn more about the project. So with that, let me turn to our next recommendation, our second recommendation of the plenary session, which is protected materials in public rulemaking dockets. This recommendation comes to us from the Committee on Rulemaking. We had a substitute or acting chair for this particular recommendation, and that was Adam White. And I want to extend my profound thanks to Adam for taking the time to do this. I know he had a very busy schedule in the fall, and also, of course, for doing it so well. Our consultant on this project, whom I'd also like to thank, is Christopher Yu of the University of Pennsylvania Law School. Actually, I think the University of Pennsylvania Law School has a new name, but I don't recall what it is. First, we'll hear from Christopher on his report, and then we'll hear from Adam on the committee's proceedings. So let me turn to Christopher Yu first. Professor Yu?
Well, thank you, Matt. Can you hear me properly?
I can.
Okay. So I'm honored to have the chance to serve as a consultant on this important project on protected materials and public rulemaking dockets. The existence of this project reflects a long-standing tension between the need for government transparency in all of its dealings and the need to protect privacy. It's been recognized for a long time in the existence of FOIA and its emphasis and its on disclosure as a default principle, and the inclusion of exemptions, specifically exemption 4 and 6, and the need to protect confidential business information and personally identifiable information. Other statutes have recognized that the advent of the internet has made this problem even more acute and added new dimensions to it, underscored most clearly by the E-Government Act itself. So we decided to undertake a project. As a consultant, we decided to study this problem in a number of different ways by reviewing the statutes, executive materials, and case law, examining this tension, conducting a survey of government practices, looking at both the physical documents, NPRMs, statement, system of record notices, and the like, the websites that are used to submit comments through which the public participates in rulemaking proceedings, but also conducted a number of interviews, workshops, and a survey of all administrative conference members. And we covered both the personal information and confidential business information. And we discovered the full report you have available, but in very short order, we discovered that, in fact, this type of information does arise with some frequency. Agencies reported, 69% of them reported encountering personally identifiable information in the submissions, 48% encountered confidential business information, and with reasonable frequency, even information about third parties, roughly estimated 16% of the time, or 1 in 6 times across the entire survey. In addition, 82% report some exclusion of evidence of submissions that contain protected information, and the frequency report suggests something on the order of 23% of the time. And they primarily do so through employees and contractors, and only one agency uses artificial intelligence in their reports. In some, I would say that, in fact, there is unevenness, shall we say, across the different agencies or difference or variations in how they implement policies. And in some cases, some agencies reported not having developed internal policies for their own agency, and at least one interview participant expressed concern that because they didn't have clear guidance within the agency, individual staff responsible for making these decisions were applying their own criteria. It's not just for screening, but principles of redaction, aggregation, and different ways to protect information that needs to be withheld, but also systems for appealing decisions or requesting withdrawal of information, challenging decisions to take down or refusal to take down information. And it became clear that there was some unevenness within agencies that could use some best practices guidance. Even in addition to the development of the policies themselves, there's some unevenness in the disclosure of those policies in terms of the venues and the extent to which disclosure is made, both about the policies, but also the opportunities to submit material confidentially, how to request information being taken down, and the processes for challenging decisions. We created 10 recommendations in the report, strong presumption in favor of disclosure, and we chose to rely as much as possible on putting the obligation on the public to avoid submitting information in the first instance. It's basically the recommendations are focused on including disclosure language in key locations, including identifying certain circumstances where we believe this would be unnecessary, and also developing internal processes that are different for confidential business information and personal information, and to align agencies inside and provide a clear basis for communicating with outside parties. And there is a more hortatory recommendation to try to look at the use of artificial intelligence, as yet not widely deployed within agencies, but clearly for pattern-based repetitive information is clearly an option that is worth exploring, probably at the governmental level.
Thank you very much. Adam White, we'll hear from you now.
Thanks, Matt. Hello, everybody. And thanks very much, ACUS leadership, for giving me the opportunity to pinch hit on this committee. I found it fascinating, beginning with Christopher's really thorough and interesting and challenging report. Through the committee process, given that this recommendation pertains to something for which there's a deep and complicated and nuanced body of law, we tried first and foremost throughout the process to take the substantive law as given, not give any sort of judgments one way or another on what the laws, the Privacy Act and other laws mean, or how they ought to be interpreted, but rather take it as given. Of course, the challenge, though, was for especially the preamble in this recommendation to try to summarize things as much as possible, the state of the law, just to give people an understanding of what we're talking about. And quite honestly, it was we'll call it an iterative process. It took a little trial and error, and I'm grateful for the continued comments and proposed amendments to continue to fine tune this. So we took the substantive law as given. We take agency discretion as given, because sometimes those laws that we're talking about here are written in very precise terms and sometimes they're not. And we didn't want to try to force the agency's substantive discretion in one direction or another. And as with everything here at ACUS, we took agency's scarce resources as given. Obviously, with any recommendation, it's by its nature sort of an encouragement for them to dedicate resources in one direction or another. But we obviously recognize the fact that this could, if taken to a certain extent, could be it could use a lot of agency resources, and so we try to steer clear of anything on that subject. Just to walk through the substance of the recommendations, as you can see, we take it sort of in steps. First, recommendations for all agencies, really focusing first and foremost on notification. I think that's probably the key takeaway from this recommendation, is the more that agencies can prioritize clear notification up front, then it's easier to put the compliance burden on the public as a whole, so that they can monitor these things knowingly with full knowledge as possible of what the law is and how the agency intends to exercise its discretion to try to front load the compliance burden as much as possible on the people who know the information best, which is the people submitting the information or the people to whom the information pertains. So we begin with a series of recommendations for all agencies. Then we move on to recommendations for agencies that already affirmatively screen submitted information before publishing it online. We begin with proposal on redaction, and then if redaction won't work, we have a recommendation on aggregation, bringing together similar comments and trying to summarize them in as useful a way as possible. And then the last one is withholding the information altogether. And then last, the very briefest recommendation at the end pertains to its recommendations for agencies that already offer assurances of protection for confidential commercial information. Thanks, Matt.
Thank you very much, Adam. Thank you, Christopher. First to the manager's amendment, which you've already received. Is there any objection to the adoption of the manager's amendment? Without objection, the manager's amendment is adopted. We'll now turn to general discussion and debate. Are there any members who wish to be heard on the recommendation? I'll give it 10 seconds or so before moving on. All right, in the absence of any general debate, we'll turn first to the council's amendments. The first council amendment appears on lines 83 through 88. Or let me rephrase that. Strike that. The first council amendment appears on lines 13 through 18. That amendment, as reflected in the note from the council, would align the definition of personal information in the recommendation with the definition of record in the Privacy Act. There is a parallel amendment at lines 83 through 88. Are there any council members who wish to be recognized on this amendment? If not, I will ask the committee for its views on the subject. Let me turn to you, Adam, for your response on behalf of the committee to the council amendment to revise the definition, both as it appears on lines 13 through 18 and also 83 through 88.
I think it's very good in general. I think that we tried late in the iterations of revising to offer the OMB definition for personal identifying information as a useful one. But this is better. And I would ask Christopher, if I may, whether focusing in this way on the Privacy Act would inadvertently truncate other statutes that are relevant to the personal information that we've been talking about here. But I think at the very least, including a citation to this as an example is a good thing. And I don't know that I'd be opposed to including the reference as definitive.
Christopher, do you have any comments on the council amendment?
I'm generally supportive. I like the idea. And drafting this, working on this project, have tried to make it primarily procedural and focused, and have attempted to taking strong substantive positions of what is and is not protected information. And to the extent to which lists like this are intended to be illustrative, I think it's appropriate. I would say that different agencies encounter different kinds of problems. And there are other guideposts, e-Government Act and others that include slightly different iterations. As long as it doesn't preclude an agency from treating information that is not specifically listed here as potentially protectable, I think it's a very useful change.
And if I may, oh, I'm sorry, Matt.
Anything further, Adam?
You know, if we're worried about focusing single-mindedly on the Privacy Act, it could be sort of softened slightly by saying personal information includes rather than personal information is. But again, on the whole, I think this is a welcome amendment.
Is there any debate on does anybody wish to be heard on the council amendment other than Adam and Christopher? I'm going to recognize first Jennifer Dickey, one of our council members on this subject. Jennifer, please.
One of the reasons we were focused on including a more specific definition was simply that we recognized that the public might not have a good idea about what is included in personal information. And the original, which was sort of broader, could be, I think, misunderstood by the public to think that more is protected than actually is protected. Certainly the intention is not to preclude agencies from providing more protection for personal information, but there's also a balance to be struck because classifying too much as personal information could lead to information that's relevant to the rulemaking being hidden from public view when in fact it's not actually the type of information that is protected from disclosure by law, and perhaps that was even submitted by a commenter with the intention that it be made public. So that was the goal here, is trying to sort of focus more specifically on the type of information that is protected to avoid sort of, to strike a better balance in terms of the various interests that are at play.
Thank you, Jennifer. That's very, very helpful. I'm going to recognize now Robert Gerard, who has a comment, I believe, on this issue. Rob?
Yeah, thank you. I think that it's a very good addition and informative. I do think that it appears to be an exclusive list because protected personal information could also include things like indebtedness, credit history, or personal identifying information that in combination could be used for fraudulent purposes, such as social security number, date of birth. So I think it would be helpful in line 16 if a qualifier were added. So for example, criminal or employment history or similarly sensitive information.
Jack Biermann is recognized.
Yes, I think this is a great definition, better than the one that I had proposed in the amendment. And so if this passes, obviously my amendment becomes moot. Not the one on the same page, but my separate amendment. But I don't understand the inclusion of the language that is maintained by an agency. That is the way that the Privacy Act and the Freedom of Information Act interact. And I don't think that's necessarily relevant to this, because the information that might surface in a comment would not necessarily, I don't think it necessarily would be maintained by an agency. So unless there's someone can explain it, my inclination would be to strike the words "that is maintained by an agency" from both of the places where this definition occurs, and leave the rest of it as is. So I would hope that would be a friendly amendment, unless I'm misunderstanding something. But I would like to amend the amendment to that effect, if possible.
Anyone else on this anyone else on this amendment or this issue? What I'd like to do, for reasons that I trust are clear, are take a vote on the council amendment because the council is not in a position to negotiate with other members of the conference about changes to its amendment. So what I'd like to do is take a vote on the council amendment, and then we'll entertain any amendments to the revised text. So subject to that explanation, is there any objection to adoption of the council amendment as it was originally proposed? All right, without objection, the council amendment is adopted. Now, let's go back to Jack. And Jack, could you repeat for us, if you will, if you don't mind, what exactly you're contemplating by way of change to the council amendment that's been adopted?
Yeah, I would suggest my proposal would be to amend the language. I think it's identical in both locations in the proposal, to delete the words that appear here in line 15. That is maintained by an agency.
Does any, Christopher, you, our consultant, do you have any reaction to Jack Biermann's suggestion? And are there any others who have reactions to Jack Biermann's suggestion?
I support Jack's suggestion. The Privacy Act is about information that's already in possession of the government, therefore it's in an agency's hands. Stuff that, material that's submitted is being done by the public. And so I don't think the context in which that language is included in the Privacy Act is relevant. So I support Jack's suggestion.
Does any other ACUS member wish to be recognized on this point? Adam, on behalf of the committee, do you see any objections to Jack Biermann's change?
No, I think and personally, I think it's a good change. I see where the maintained by an agency language comes from in the Privacy Act, but as Christopher just pointed out, we're talking about a step that's prior to the agency coming into possession of the information.
Okay. Is there any objection to striking the phrase "that is maintained by an agency"? All right. Without objection, that language is stricken. And Todd will be conforming lines, the new text on lines 13 through 18, and the text, the corresponding text in the recommendation. Is that right?
If it remains, yeah.
But for now,
For now, yeah.
Okay. All right. I raised a question in the comment as to whether the Assembly wishes to retain the definition of protected material and the definition of confidential commercial information in recommendation 1. That would be, I believe, inconsistent with our convention. Is that right, Reeve?
That's correct.
Is there any objection to striking the definitions from paragraph 1 of the recommendation? All right, without objection, the definitions are stricken. We will now turn to the pre-submitted amendments. And the first one comes from our special counsel, Jeff Lubbers. And yes?
First one, you're talking about the one in the footnotes?
Well, just hold on until I recognize you, Jeff.
Oh, you did.
You have your first, let me recognize Jeff Lubbers for his proposed amendment. It's labeled Lubbers number 1, and it pertains to the footnote. Pertains to footnote number 5.
Okay, thank you. I also hope we don't forget Mr. Gerard's suggestion that he made a few minutes ago. But so footnote 5, I was just trying to provide a little precedent for some of the recommendations, paragraphs in this recommendation. When we issued the recommendation back in '82, that's in the previous footnote, that's been added already. President Reagan issued the Executive Order 12600, which provided a protocol for handling these kinds of issues in the context of FOIA, so that when a FOIA submitter said that they were submitting some confidential commercial information, the agency would have to notify the submitter whenever somebody requested that information. And furthermore, if the agency then did not disclose it, if the requester went to court, the submitter would be notified that that was happening too. So I just thought it was a good kind of precedent that shows that there's a way of handling this under FOIA, which is not dissimilar to the way that this recommendation suggests handling it in the rulemaking context.
Is there a voting member who wishes to move Jeff's amendment to footnote 5? Ron Cass has indicated that he moves the Lubbers Amendment to footnote 5. Is there any objection to the adoption of the Lubbers Amendment number 1? Without objections, it's adopted. We'll now move to the next pre-submitted amendment.
Is it interesting?
Hello?
But I had, yes, I had a big problem with my computer, but it's been solved, I think, maybe.
And the spell check thing, did he fix it?
Alan, could you unmute yourself, please?
Yes.
Or why is Alan,
I have no idea.
why is Alan's mic still on? Jeff reminded me that I skipped over Bob Gerard's comment or amendment, which was to the text amended as a result of the council amendment, lines 13 through 18. Rob, let me recognize you once more to ask if there's an amendment that you wish to move.
Yes, sir. It's on what would now be line 14. It would be after criminal or employment history, comma, add, or similarly sensitive information. And then a conforming change, delete the and before criminal.
And could you just explain briefly what the basis of that amendment is?
Yes, it's that as written, it looks like an exclusive list of criteria for personal information. And there's other categories of information that could be equally sensitive, such as, for example, social security number and date of birth, which in combination could be used for identity fraud.
Okay, is there any objection to the Gerard amendment to add the phrase or similarly sensitive information? Without objection, the Gerard amendment is adopted. Let's move on to the next pre-submitted amendment, which is Jack Biermann's amendment. Jack, could you identify your amendment and explain its basis, please?
Right, so on line 23, that's the one we're talking about.
I think it's what's up on the screen is now lines 21 through 23. Is that correct,
Okay,
Todd?
yeah. Right, on line 21 through 23. Yeah, I thought that there could be an issue about if an agency wants to use protected material in its rulemaking explanation, feels like it needs to, the agency can be in a sticky wicket if it also is trying to follow this recommendation. So I just wanted to make it clear that we weren't taking a position on that. That's all.
I'll ask if any members have any comments on Jack's amendment, but before doing that, let me turn to Adam White, the committee chair, and to see if he has any reaction to Jack Biermann's amendment.
I think it's a good example of trying to make clear the limitations of the scope of this recommendation. So I welcome it. I'd say I don't know if there's a difference between an agency desiring to rely on something rather than an agency relying on it. I don't know if that's a nuance that needs to be ironed out, but on the whole, I think it's welcome.
Christopher?
I concur.
Does anybody have any concerns that the phrase rulemaking explanation is not sufficiently precise? Ron, I'm going to recognize Ron Cass now, who has a question.
Yes, I have a question for Jack, and that is, what sort of circumstance do you envision where an agency would need to use individually protected information in its rulemaking about an individual that identifies an individual?
Well, I was thinking more about confidential commercial information, that might be more likely to be used, because you could imagine regulation of products or industrial practices and that sort of thing, or financial products, and so protected material covers both the individual and the business information. So I was thinking more in line with the business.
And you're thinking of this in a rulemaking context, because again, I'm trying to get a handle on what particular sorts of rulemaking would be disclosing in the rule a confidential, either personal or commercial information.
I was thinking of a situation of imagining, for example, regulating a motor vehicle technology, and the technology was revealed to the agency as confidential business information, something like that.
I'm sufficiently, I'm having sufficient difficulty of envisioning a circumstance where this is both desirable and necessary, to be skittish about putting in phrasing about this until we have more information. I understand where you're headed with this. I'm just not sure I see the parameters sufficiently to be comfortable with modifying the recommendation yet.
Jack, any response?
Yeah, I don't really have a response to that. I mean, I think, my view, if other people share the skepticism that this is really relevant, then, that's, I don't feel, I don't think it's a necessary addition to the recommendation, but I just thought that one of the primary uses of information that agencies use is to decide what to do in their rulemaking, and then when any information they use to decide what to do in their rulemaking, they need to disclose it in their concise general statement or whatever explanation they're giving. And so, I think it's sufficiently important to worry about. But if it turns out that I'm talking about the null set, then other people with more experience in what actually happens in rulemakings, I'm happy to go along with Ron's suggestion not to go forward with it. But I'd be interested to hear what other people think.
Are there other members who have a wish to share a perspective on this amendment? Christopher, you, please. And then Adam White.
My apologies that I can't cite chapter and verse on this quickly, but as I recall, in one of the interviews that came up, one of the agency representatives did indicate that they had information about a particular technology in the context that Jack mentions, a trade secret or confidential business information, which was about the feasibility about a certain technology or a certain solution happening, that they felt that they did rely from time to time on information they regarded as protected as part of their rulemaking. That creates a great challenge in terms of giving people the ability to respond, to ventilate the issue in the way that we all are familiar with, and that goes into the disclosure of redacted information, reasons for and such. But I do recall from one of the interviews, one of the agency members we talked to did suggest the scenario that Professor Biermann has raised.
Adam White.
In terms of the concerns that Jack is sort of intuiting here, in my past life as a pipeline lawyer, I remember submitting lots of confidential security information to agencies for variety, especially FERC, for a variety of reasons, and then fighting disclosure of it, after the fact, either mostly in the FOIA context, but just in general. So I do think it's a worthwhile concern. My main point, though, is that this paragraph specifically is really focused on the definition of protected material. Whether ACUS as a whole adopts this Jack's amendment or not, I think the better place for it is actually two paragraphs later. It's in the paragraph that begins, "For all agencies whether to withhold or disclose protected information is governed, et cetera, et cetera. This probably fits best in the middle of that paragraph before the sentence that says, although a full description of those laws, because that really is the paragraph that turns to the process that we're talking about, and not the definition of the universe of materials.
Jack, your thoughts on the placement of your amendment?
Yeah, I agree with that.
All right, so you're proposing your amendment, that your amendment be moved to,
yeah.
Do you have it up, Todd?
Yeah, can you just, what paragraph is that again, Adam?
For all agencies is the paragraph.
Yeah,
So it's on line, it would go in at line 33.
Got it.
Kristen Hickman would like to be recognized on this amendment. Kristen, please.
Thank you, Matt. So in general, I support this amendment to the recommendation. I don't want to let drop the observation that I believe it was you, Matt, who made very briefly that rulemaking explanation is a little bit clunky and unclear. You know, in notice and comment rulemaking, I would just say regulatory preamble, because I think that's where it would be discussed. I don't know, and this is as much a question for Jack as anything, you know, whether this recommendation reaches rulemakings that don't have a regulatory preamble, at which point I'm not sure what alternative term to put in. But that's, so I guess that's part of my question, is this recommendation really limited to notice and comment rulemaking or other rulemakings like IFRs where you're going to have a regulatory preamble, at which point can we just say regulatory preamble? Or is it intended to reach more broadly than that? I would also just separately suggest, as I think it was Adam sort of mentioned earlier, that instead of saying desires to rely, why don't we just say relies?
Might I respond, Matt?
Yes, you may. Are you okay with the friendly amendment of Kristen to say relies?
That was what I wanted to respond to. Well, actually,
Okay.
I respond to both. So
Please.
First of all, the thing is there's preambles, there's concise general statements. There may be NEPA reports, you know, environmental impact statements. There may be impact statements under Small Business Regulatory Flexibility Act. That's why I use the generic word explanation, because I felt that it needed to capture many different possible ways that the agency might feel, you know, needed to have information. On the desires, you know, I understand that, but the reason I said desires was because the agency might be in a difficulty, you know, and it was, so the word desires, you know, the agency is trying to figure out what to do. If to say just relies on it, then it's assuming they already did it. And I didn't want to judge. Maybe there's a better word than desires, like intends to, or something like that, to say that it hasn't happened yet. But I didn't want to say that they already did it, because it may be that they can't do it if it turns out that the information is confidential.
Kristen, back to you, please.
Sure. Maybe we could use wants instead of desires, but I don't really care too terribly much. I as far as that goes, I take your point, Jack, and I'm fine with leaving it as is or going with, as Ron Cass suggests here, chooses or wants or something like that. How about instead of saying rulemaking explanation, I take your point there too about NEPA, et cetera, et cetera. What about in explaining its rulemaking, as opposed to rulemaking explanation singular? Would that be better and still capture what you're trying to say?
Jack?
Have the ending be in explaining its rulemaking?
Yeah.
That's fine.
Thank you.
It's better English too. Ron, Ron Cast, you're proposing to change if an agency desires to if an agency chooses, Ron?
Yes, I was proposing that. I am proposing that. I also have a question when we change it to in explaining its rulemaking. My question is whether that is explaining it anywhere to anyone. What's the universe of explanations we're now talking about? I understood Jack's original language to be confined to explanations that arise in the rulemaking itself, but I'm not sure that the changed language is that limited.
Adam, I'm going to recognize Adam White and then Jack if he wishes to be heard once more. Adam?
Thanks, Matt. Thanks, Matt. Ron, I think, touched on what I was about to say at the very end, that we're talking here about the rulemaking process, and the simplest thing might just be to say, rely on protected material in its rulemaking.
Jack, Ron, or Kristen?
Well, I like Ron's word. I like the word chooses. If people are concerned about desires, chooses is, I think, the best alternative. But I think that I'm trying to reach the explanation, because it could rely on it in its rulemaking, and then, you know, what it does, how it explains it is the issue is disclosure, not what it considers. So I think I like my original version better than Kristen's modification, but I'm happy enough with either of them.
I think
just wait to be recognized, because otherwise we're not going to have an adequate record for the court reporter and so forth. So Kristen is recognized now.
Thank you, Matt. So I don't want to belabor this. I think the concern that I had about rulemaking explanation is then, Jack, your explanation of that language was it could be the regulatory preamble, it could be a concise general statement of basis and purpose, it could be in a NEPA report, you know, so the word explanation singular did not strike me as capturing that universe of documents. Let's put it that way. And it's not a generally, you know, when we talk about a rulemaking explanation, I don't think of that as being a term of art in the administrative law space in general that is understood to encompass those documents. So, you know, I think that was my concern, was that rulemaking explanation, with explanation being singular, didn't mean anything to me. And you're trying to capture a concept. So, you know, maybe explaining, you know, maybe going to Adam's compromise as in its rulemaking is at least, you know, kind of gets away from what do we mean by explaining and how broad is it supposed to be?
Jack?
You know, I'm relatively agnostic on this. I'm happy either way. I'm more concerned that something to this effect get adopted. So, you know, I don't know how to proceed past that. Maybe Adam ought to make the decision. Adam says he has a comment on this, I believe.
Well, I think he already made his comment. I mean, as Ron Cass has suggested, we could remit this to the Committee on Style.
That's fine with me.
Ron, let me turn back to you. Do you have a continuing objection to the inclusion of this, the material that's now in lines 33 through 35, with the result that I will take a voice vote?
I would say I don't have an opposition to it. I have qualms because I still am having trouble seeing the full scope of what this reaches. And obviously, since it isn't covered in the report, I can't look at the report to get that out of it. But I take Jack's explanations and Adam's and Christopher's together, that there is something here to be addressed. And as long as we can cabinet appropriately and the Committee on Style can come up with language about the where it would be explained, I would not object to it.
Is there objection to the Biermann Amendment, that is the language that's been added to lines 33 through 35, subject to any revisions that the Committee on Style deems appropriate in light of the discussion? Any objection? Without objection, the Biermann Amendment is adopted, subject to the qualifications that I noted. The next pre-submitted amendment comes from James Anderson on lines 90 through 91. Is James here to address his amendment? James? No, James is not here. We'll move on to the next amendment. If at the conclusion of the discussion of the pre-submitted amendments, any member wants to revisit this pre-submitted amendment, we can do that. So what we'll do now is we'll turn to the Jeff Lubber's second amendment, which is marked Lubber's Amendment number 2. And that appears on what's now lines 122 through 124. I'll recognize Jeff to speak to his amendment, proposed amendment.
Thank you, Matt. Thank you. This is just a cross-reference to the recommendation that we just adopted.
Is there a voting member who wishes to move Lubber's Amendment number 2? Sid Shapiro, a public member, is now moving Lubber's number 2 as an amendment. Is there objection to Lubber's Amendment number 2? Without objection, Lubber's Amendment number 2 is adopted. We'll now move on to the next pre-submitted amendment, which is Lubber's Amendment number 3. Do we have that up on the screen, Todd? Yeah. That's at what's now 135 through 136. And there is a corresponding change at 141. I'll turn it over to Jeff to identify and explain his amendment, Lubber's number 3.
Okay, I'm just trying to complete the circle in this recommendation because it says that if the agency agrees with the submitter's essentially petition and they withhold it, they should remove it. But what if they don't agree with the submitter's petition? In that case, Section 555 of the APA says that they should promptly notify the submitter of this finding with a brief statement of reasons. So I'm just trying to add what would happen if the agency does not agree with the submitter's request.
Adam White, may we turn to you and then Christopher, you to see if you have any reactions to Lubber's number 3?
I think it's a good addition. I think it's phrased at a sufficiently high level of generality that it doesn't command too much in terms of specifics. But I would acknowledge that this is an example of something that's going to go to the point about agency resources. And so folks with concerns about that might have concerns about this amendment.
So it's already, my response is that it's—
Hold on, Jeff, Jeff, we recognize Jeff Lubbers. I just need to do this, Jeff, for the court reporter.
Okay, sorry. Yeah, I just point out to Adam that this is basically already required under the APA. That's, so they have to do it anyway. And Ron Cass has a suggestion, word change.
Well, hold on, let me recognize Ron. Do you have anything further, Jeff?
Not on this one.
Okay, I'm going to recognize Ron Cass now.
I just had minor grammatical issues. I just thought we should change agency to agent, for agencies to agency, and they to it, because we're talking about a single agency's action here, not a group of agencies.
And that's acceptable to you, Jeff?
Yes, if an agency, yes. If an agency determines.
Does anybody, are there any other members who wish to be recognized on Jeff Lubbers' amendment? Is there a voting member who wishes to move Lubbers' amendment number 3? Ron Cass moves Lubbers' amendment 3 as Ron Cass moves Lubbers' amendment number 3. Is there objection to the adoption of Lubbers number 3? Without objection, Lubbers' amendment 3 is adopted. And we have that accurately reflected on the screen, right, Todd?
In progress.
Okay. I didn't mean to rush you. I'm just.
Okay.
The next amendment is from, the next pre-submitted amendment is from James Anderson. I do not believe that James Anderson is present.
Excuse me, Matt.
Yes.
You skipped over my one number 3. The second part, the part on paragraph 5 is a little bit different. It shouldn't say they should promptly notify the submitter. They should promptly notify the requester. Because it's a different person, it's a third party that's making the request.
So tell me, Reeve, where are we here? Because this was treated as a single amendment and I so treated it, so.
Yes, so, Todd, can you scroll down? I think it's the language.
142 to 143 on the screen.
Okay, and 142, strike submitter, change to request.
All right, there's no objection to that, is there?
No, they should.
Okay, without objection, we'll make that conforming change to the amendment. Are there any other amendments to this recommendation that anybody wishes to move? I'll give everyone 20 seconds or so to let me know if there are any other amendments. John Duffy has asked for recognition and Alan Morrison has asked for recognition. We'll start with John Duffy. John?
Hi, thanks for recognizing me. Maybe I am having trouble understanding part, well, it's lines 100 in the original markup. It's subparagraph C, which says instruct members of the public never to submit protected material that pertains to third parties. And because we've defined protected material so broadly, including things like educational qualifications, I'm just wondering, this is a pretty broad instruction. I mean, it's unqualified. And I could think of lots of times when maybe the public wants to comment on, let's say, an expert's qualifications, something that might have been disclosed under Portland Cement, and they might want to say, well, this expert, doesn't have the requisite credentials to really opine on this technological issue. They could also get consent from third parties. So, for example, trade organizations often submit comments, and they might submit a comment that has data from a company that they represent, and they've gotten the permission of that third party. So I guess I'm just trying to understand the motivation for such an absolute prohibition. And I worry that agencies could say that, some members of the public are abusing the rulemaking process by doing this, which I would think that this is fairly common, that this kind of material, because the definition of the protected material is so broad that there'd be a lot of it there that happens. Thanks.
Adam White, do you have a reaction to John Duffy's comment?
It's well taken. In the lines a little earlier than that, on the printed version, it was around lines 91 to 92. The recommendation specifically calls on agencies to describe in advance what they consider to be protected materials. And so that limits the universe of things a little bit if the agencies comply with that part. But that's just an observation. On the whole, I think that John's point is very well taken. And I don't recall why these lines were drafted so categorically.
Christopher, do you have any thoughts on this comment, the comment that John Duffy has just made?
I concur with John's comment, Professor Duffy's comment, and with Adam's reaction to it. One solution might be, instead of saying never to submit, could be to say to avoid submitting, but that is a decision for the assembly.
John, is there a, Ron Cass, did you wish to be recognized? Ron Cass does have a, I'm going to recognize Ron Cass now.
Thank you, Matt. I think that John is right. We should find a way to limit this. And instead of saying never, perhaps what we should say to take care in submitting protected material that pertains to third parties to assure that I'd like to capture John's point about getting their consent, or that there is, at least some thought paid to this and that the material is flagged. Because I think we do have a large universe of material here that we're talking about. And I don't know if John has in mind a particular formulation of words, but I think we want both to limit the never to a caution, and to include in the instruction something about doing this without, authorization. So certainly, if it's authorized, that puts it in a very different category.
I recognize Alan Morrison now, Senior Fellow.
On this point, I have a thought to follow up on what Ron Cass just said, something along the lines of members of the public should be cautious about submitting protected materials in terms of third parties. And I have another comment as well, but that's, let's finish up on this one.
On a separate subject, you have a comment?
I do.
Okay, just hold that. I'll come back to you in a second here. I'm going to go back to John Duffy if he would like to be recognized further on this point, and whether he has a specific amendment to offer on lines 99 through 100. John?
So I thought about including authorization or consent of the third party, but I think that that's too limiting, because, like, for example, if you're going to say an expert that the agency is relying on in materials that it submitted, that it disclosed to the public under Portland cement, you might not get the expert's consent to say, hey, their degree doesn't really cover this area of expertise, and they're not a qualified expert. They wouldn't survive a Daubert motion. So I think that either of the suggestions of Ron Cass to sort of take care in submitting, or I think Alan Morrison's suggestion that I forget exactly what he said, but to use caution in, some sort of language like that. I think we can't just make it a permission thing, because I think there's sometimes when it might be very necessary for a member of the public to say something quite negative about a third party that's highly relevant to the rulemaking, and you wouldn't get that third party's permission to disclose that negative thing. Thank you.
John, do you have a preference in terms of the phrasing of the amendment?
Instruct members of the public. No, either's kind of vague, and that's okay. I'd love to give, I wish I could have given, I thought there was some rationale behind this, and that's what my original question was. I suppose I like caution a little bit more because it is to be cautious in submitting protected materials that pertain to third parties. And then the agency does have these later procedures where people can object and they can figure out whether to exclude it from the public rulemaking docket. But I think that's better because take care. I think caution is a great word to have in there. So I think that's Alan's word. So Alan, my former colleague, hats off to you. I like that word.
So
to be
let
cautious
me,
in submitting.
did you have anything further, John?
No, I like it the way it is, except strike out the include language about authorization. I think that's negative. I think that's bad.
All right,
Okay.
I'm going to recognize Adam White, who may have a further drafting suggestion on this amendment. Adam, please.
Well, focusing on the word cautious, it starts to raise some of the questions we grappled with throughout the committee process about suggesting that the ACUS is offering a substantive view on the law or policy here. I would suggest something much more general and just say, instruct members of the public that the disclosure of protected material may be prohibited by law, and sort of stay away from any kind of shading in terms of intentions or risk analysis about whether to submit. John's point is very very well taken in general, and I'm glad that we're revisiting this language. It's just the word cautious that's so vague that it brings me back to the committee process where we grappled with these sorts of things.
Well, let's return to John Duffy on this point and see what his reaction is to your reformulation. John?
I'd view that as better. I think, yeah, I welcome the committee's suggestion, obviously, of discuss this more.
And Ron Cass, you like it too?
I can accept it. I'm not sure it captures the thought that I thought John was raising, that not only may it be prohibited at times, it may raise issues that are unnecessary and that are problematic, and that those are things that should be kept in mind as well. I think never was too broad a term, and I think John was absolutely right on that. I think limiting it to legally prohibited disclosures may be too narrow. And again, I don't have particular language that I'm wedded to or think captures the space in between.
John Duffy?
Well, Ron is certainly right that this is very narrow, but I guess my main goal is to get rid of, my main goal is never to say never again, sort of, more than anything else. But I think this is very narrow. Ron's right that it does lose that other thought that they should be cautious. It just remains, it doesn't take a position on that. But I'm trying to draft here on the fly. I certainly think I would agree. I would vote for the amendment as it's written right now. If we want to tell people to be cautious, maybe that should be another bullet point. But if the committee's already discussed that at detail, that they don't want to make sort of substantive recommendations, I think then we should not do that on the floor like this.
Well, John, I can give you two choices. We can either move your amendment, or I can give you 2 or 3 minutes to think about it while I ask if there are any other amendments. What's your preference? Michael, let me recognize Michael Livermore, who has a suggestion here. Mike? Michael Livermore?
Sorry, I was muted. Provide guidance to the public concerning the submission of protected material that pertains to third parties. Perhaps that's a way to cut through this.
Let me go back to John Duffy on this one.
Well, that's consistent with sort of the A and B and C and D. It's all of those we're sort of saying the agency should let members of the public sort of know what the ground rules are. And this one said, don't do something, which was different. So Michael Livermore's comment, I think, is I'd be happy with it. Again, my major goal is to get rid of the flat prohibition.
Ron Cass seeks recognition. Ron?
Yeah, I was just going to say that I think that the suggestion here, while it's trying to do what I was trying to do, I think it is a little more in the category of some of the other numbers here, some of the other letters here. So I think much as I'm uneasy with the prohibited by law one, I think that may be better for this particular letter.
All right, so let's go back to John Duffy, and I'll ask you, John, if you would like to, how you'd like your amendment to be phrased. And again, if you want me to move on and ask to see if anyone else has any other amendments while you think for a few minutes, I'm happy to do that.
Why don't you do that? And I'll maybe try and splice together some of the thoughts.
All right, well, we'll see if anybody saves you and gives you a little bit of time here. Are there any other amendments from the floor? I'll recognize William Funk. Bill?
If we adopt C in any of the forms we've talked about, you have to do something about D as well, because it's absolute as well, and says you have to remove the information that's provided in C.
All right, hold on this one. Alan Morrison, do you have a proposed amendment that does not relate to this subparagraph C?
Yes.
Okay, please, let's hear it.
All right. This is recommendation number 7. And it's partially a way of a question to the committee. It says redaction is not feasible. Agency should consider presenting the data in a summarized form. Did the committee consider asking the submitter to submit a redacted version? Because that would seem to me, A, to make the agency have less work to do, and B, assure that the redaction is at least sensible from the submitter's perspective.
Adam White?
So this recommendation is in the section that's focused on agencies that are already screening for protected material. And so it's assuming sort of an active role by the agency along the way. I'm looking back now in recommendations for all agencies. I mean, in a way, I think, Alan, what you're suggesting is sort of just a reiteration of this initial recommendation that agencies should tell the people, don't submit this stuff. And redaction is a form of not submitting this stuff in the first place. I think it's an option. I don't think, though, that we specifically, I don't think during the committee process we talked specifically about the public submitting redacted materials, although of course in practice that's something that just happens.
Yeah, I was going to say.
Wait, Alan, please.
I'm sorry.
You're recognized. Alan Morrison is recognized.
Sorry, Matt. In litigation, that happens all the time, that somebody submits something and says, keep it under seal. The judge turns around and says, no, at least submit a redacted version. And all I was suggesting is that that's something that the agencies could and should do. And it keeps us further away from the problem about whether an agency can rely on material that's not public.
Can we look at, Todd Rubin has asked that we take a look at recommendation 12C. Does 12C allay your concern, Alan? Alan?
I'm looking, I'm trying
yes, he's on.
to have
Thank
multi-screens at the same time is not my forte. Yes.
Okay, so you're happy, Alan.
I think, yes, I just, okay. Overall, it's okay. Yes.
Okay, so John Duffy's amendment aside, are there any other amendments from the floor? No. Let's turn back to John Duffy. And in particular, let's get up on the screen, Todd, paragraph 1D, I believe it is. Is that correct? C and D. John, you're recognized. John Duffy.
Thank you. So I think maybe combining a little this language would work. So provide guidance to the public as it is concerning the submission of protected material that pertains to third parties, comma after parties, including instructions concerning, or including instructions that the disclosure of protected, sort of go to the next blue phrase there, that the disclosure of protected material may be prohibited by law. That gets that thought in there. And so that's, I think, gets the major, I think that gets, and I should say that the disclosure of some protected material may be prohibited by law, because I think that.
Okay, John, anything further on subparagraph C?
No, but I do agree that D has to be modified in some fashion.
Okay. Do you want to take a stab at that, or shall I recognize Ron Cass first?
You should recognize. I think we should focus on C before we do D. So recognize.
Okay.
Ron is going to focus on that.
Let me just turn to Ron Cass to see if he has any comments on John Duffy's revised amendment in subparagraph C. Ron?
I'm fine with John's revision of paragraph C. When you get to it, I have a recommendation for paragraph D.
Are you content if we take a vote first on subparagraph C?
Happy to do it any way that works.
Okay, John, are you content to have a vote on subparagraph C? Can we do that?
Yes.
All right, is there any objection to the Duffy amendment reflected on lines 99 through 102? All right, without objection, that amendment is adopted. And now we'll turn to Ron Cass for an amendment to subparagraph D, which is now on lines 102 through 103. Ron?
I would substitute for the word "it" at the end of the paragraph, and I would put in any such material that is not essential to the comment.
Anything further there, Ron?
That's it.
Let me turn to Adam White for his reaction to Ron's proposed amendment.
I think it's fine.
Is there any objection to the Cass amendment in lines 103 through 104 as it appears on the screen? All right, without objection, that amendment is adopted. We have no more amendments. Is that correct, Reeve? Todd?
We want to return to the Anderson amendment?
Is there, unless there's a member who wished to take, no.
Okay.
I mean, haven't I already, okay. No, I mean, I think that, I'll ask one more time. Are there any voting members who wish to propose any additional amendments to this recommendation? All right, hearing none, we will move to a final vote. Please turn on your, please unmute yourselves. All those in favor of the adoption of the recommendation, please say yay.
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 Opposed, nay. All right, the yeas have it, and the recommendation is adopted, with my thanks in particular to Adam White for pinch hitting, as he put it, though I think you did more than that, Adam, and also Christopher, you, not only for an outstanding report, but also spending a lot of time with the committee during the drafting process. Before we move to the next item on the agenda, which is artificial intelligence, we'd like to take an unscheduled 5-minute break, and it appears as though our schedule will allow that. So we'll go offline for 5 minutes. Thank you. Thank you. We'll resume now with our third recommendation, actually a statement, agency use of artificial intelligence. This comes to us from a special ad hoc committee of ACUS members, or maybe I just should say ad hoc committee. Mark, do we have a list of the ad hoc committee members to put up on the screen? Could you put that up, please? The members of the ad hoc committee are all on the listed on the screen. I want to extend them our profound thanks for the enormous amount of time that they spend working on this statement. I also want to thank the special invitees whose names are listed on the screen, all real experts in AI, for contributing their perspective and insights during the committee process. If you just go back to the previous slide, thank you very much. This statement draws on 2 reports commissioned by the conference, to which I had alluded earlier during my opening remarks. One is a report drafted by a team at Stanford and NYU, consisting of Dan Ho, David Angstrom, Catherine Sharkey, and Tino Cuellar. I want to extend them our really most profound thanks. I know that they spend an enormous amount of time preparing the report, Government by Algorithm, and I know that Stanford and NYU devoted a lot of resources to this project through its graduate students and otherwise. And I also, of course, want to thank Kerry Colanese for his excellent report, which also underlies this recommendation. Thank you, Kerry, again, as on so many other occasions, for your outstanding contributions to ACUS. I also want to thank, and I think I overlooked it, our committee chair, John Cooney, who is now a senior fellow, and he came out of retirement, so to speak, to chair the committee at our request. John, no one chairs a committee as skillfully as John, and we asked him to take this one over because we knew that there would be evident challenges that the committee would have to deal with, and we thought no one was more suitable than John. So thank you, John, for all the time you spent. Thank you for the late nights, and thank you to our consultants and our staff attorney, Deputy Research Director Mark Thompson, for the late nights he spent drafting this recommendation. Let me now turn it over to our research consultants on this. We'll hear first from Dan Ho. Dan, are you there?
I am here. Thanks so much, Matt, for that introduction, to Mark for his really spectacular work in putting this all together, and to John for chairing this really exceptional committee. I thought I'd just give a few quick minutes of an overview of the underlying report and its background. So this was a class we offered joint between Stanford Law School and NYU Law School in starting January of 2019. With David Engstrom, Tino Cuellar, and Kathy Sharkey. We had roughly 30 students, 10 or so computer scientists, 20 law students doing research on this that culminated in around a 120-page report to try to really take stock of the use of AI by federal regulatory agencies. Brief overview, because there's no way I can really go through all of the detail. The report comes in 3 parts. It's available online, of course, to any of you who want to take a deeper dive. The first part does a kind of systematic canvas across the 140 most important agencies measured by FTEs to really understand what's going on in terms of the use of AI and machine learning within these agencies, and basically finds that there is fairly high penetration, with roughly half of federal agencies having experimented around with forms of machine learning, but fairly high variance in sophistication and little documentation of these techniques. Second part of the report goes through and does a number of in-depth case studies based on interviews with government officials and developers. So thank you all at ACUS for helping to connect us with the relevant folks. A couple of examples are that some of you may have heard about at an earlier plenary is the Securities and Exchange Commission has been using natural language processing to go through publicly filed reports, for instance, to identify insider trading. The Social Security Administration has built out an NLP, natural language processing-based system to flag quality problems in draft decisions by administrative law judges. And the Consumer Financial Protection Bureau has done some experimentation to help use machine learning to do complaint and comment processing. And the third and final part of the report spells out some of the legal and policy implications, many of which show up in the statement you have before you. I'll just highlight 3 very briefly. I think one theme that we heard throughout this engagement is the importance of capacity within federal agencies and the need to have folks with both domain and technical expertise to foster the kind of internal accountability and governance to develop these tools in the right way. That is related to some of the challenges we heard about when these AI tools are procured through contracting, where there are instances of agencies being unable to determine the source of errors, for instance, in a facial recognition technology system. Second theme is about how much context matters here. So for instance, if we're thinking about source code transparency, that may be very desirable when we want to make clear what the criteria are for benefits programs, but much less desirable for enforcement purposes, where reverse engineering by regulated parties may be a concern. And then the third kind of theme in the final section of the report is really about, I think, the part that shows up in the statement on demographic bias and oversight. So these are by and large systems where the AI tools are used still by human decision makers, and sometimes human decision makers over-rely, what is referred to sometimes as automation bias. Sometimes they under-rely, which is sometimes referred to as algorithm aversion. And so it's really important to have rigorous forms of performance assessment with that human impact in mind. So that's the kind of report in a nutshell, and I'll turn it back over to Matt.
Carrie, we'll hear from you now, please.
Thank you very much. My thanks as well to John for chairing this committee, Mark for providing excellent staff work. I am building in some sense on the report that Dan just described. It's no surprise that there is interest in and use of various types of algorithms by government agencies today. These tools that this draft recommendation addresses sometimes are referred to as machine learning algorithms, or just under the banner of artificial intelligence. They're being used widely in the private sector, in the world of medicine, because they can generate highly accurate forecasts and make, in certain cases, better decisions and better outcomes than humans. but they have garnered some suspicions and concerns. Dan mentioned, for example, certain kind of biases. They can be autonomous, they're learning algorithms. They can be somewhat opaque. The question ultimately, though, that I frame my report around is not whether machine learning algorithms or artificial intelligence is perfect, but how does it perform compared to what? And compared ultimately, I think, to the status quo today, they should be assessed against how well they perform compared with human judgment. And my report provides ACUS and government agencies with a framework for making a choice between when to rely on the status quo and when to make a decision to go forward to automate or develop a system that relies on artificial intelligence to supplement or substitute for existing processes. It begins by showing the broad range of research that reveals how flawed human judgment can be, whether it's in terms of individual biases or dysfunctions of group decision making. It recognizes that machine learning can overcome many of these biases. It can have certainly its own disadvantages as well. It spends a fair amount of time discussing some of the legal questions related to the use of machine learning algorithms in government, arguing that there's nothing intrinsic or inherent about the use of artificial intelligence tools by government that would raise legal concerns. If managed and used responsibly, artificial intelligence can be fully consistent with current administrative law principles. In fact, in some respects, it may be almost required under existing administrative law principles when a tool is identified that can perform better than we currently can do through human decision making. Ultimately, the key is to make a policy or managerial judgment as to when to use artificial intelligence. And toward that end, the final section of my report offers a multi-factor policy framework for considering the use of artificial intelligence tools. It organizes those factors into three main categories. The first one is whether the situation in which the machine learning tool would be used satisfies the preconditions for effective use of machine learning algorithms. Specifically, is the goal something that can be stated clearly and with precision? Are there sufficient data available? Do those data provide adequate external validity for the problem at hand? The second set of factors focuses on outcomes themselves, and does the algorithm or the artificial intelligence tool provide improved outcomes in terms of both performing at the goal, having impacts on those who are directly affected by the algorithm, and impacts in terms of other members of the public. And finally, the third category is the legal and political and public acceptability of the use of algorithms. And I distinguish between the extent to which government would rely on an algorithm, whether just for an input into a decision or to actually substitute for the making of the decision, and the degree of stakes at issue, and provide a matrix for considering those issues of legal and public acceptability. Ultimately, again, the question is compared to what? And I think the draft ACUS recommendations, or draft ACUS statement, I should say, will provide government agencies with an excellent checklist of issues to consider as they go forward and make a decision about when and whether to use artificial intelligence tools. Thank you.
Thank you, Kerry, and thank you, Dan. We'll turn to John Cooney now, the committee chair, for some remarks on the course of the committee proceedings. John?
Thank you, Matt. It was a privilege to be associated with this extraordinary project. My understanding is that ACUS started the process by reviewing how AI is being used by 144 federal agencies or entities of some kind or another. And then, as Matt mentioned, 2 sets of consultants were brought on board, people who had familiarity with how AI is used in the public sector and in the government sector, and knowledge of how the legal system is handling the issues presented by AI. Our ad hoc committee consisted of 45 people with experience with AI, representatives of government agencies, private sector experts, and special invitees with unique knowledge about AI. The committee met through 4 virtual Zoom calls. Each call lasted 2 hours or more. It was quite an experience. The committee also went through several rounds of comments from its participants. And it's hard to describe how hard Mark Thompson had to work in his role as a translator of this project. He translated technical concepts into language that non-technical personnel, both on the committee and in the agencies, would be able to understand. And he translated legal concepts into language that technical personnel could understand. So he had to run interference back and forth to get everybody on the same page, quite literally. And some of the comments on the statement, as you'll see, involve this kind of technical language. So it was an important task to have accomplished. Mark also had to have repeated discussions with proponents of the comments to make certain he caught their technical expressions and their legal views correctly and could get them into the next draft of the paper. So he was really working extremely hard to bring home a difficult subject, and he managed to do that very well. And we all thank him for pitching in and doing that work. Now, for lack of a better term, a committee on style was organized to work through the Thanksgiving weekend to try to incorporate the comments from the 3rd committee meeting and get them into the draft statement, and then fine tune the drafting of the statement so that it would be acceptable to the members of the plenary. And the statement, I'm happy to report, was approved by acclamation on the Monday of just after Thanksgiving. So we managed to come out with, as I said, approval by acclamation. It was everyone was quite happy with the result. And so we look forward to hearing your comments on the statement as it stands today, and working through this to try to get the best product that we can release as a statement to the agencies and others who are interested in use of AI by the federal government.
Thank you very much, John. We will in fact turn to the to see if there are comments on the statement. Before doing that, though, I'd like to turn to the manager's amendment. Is there any objection to the adoption of the manager's amendment? Without objection, the manager's amendment is adopted. Do any members, are there any members who seek recognition to make any general comments about the statement? I'll give you a few minutes to type into the chat if you wish to make comments. All right, no general, not hearing from anyone, we'll proceed directly to the pre-submitted amendments, and then we'll turn to any floor amendments that any members may have. We have a number of members of the council. We have a number of amendments from the council. Some of them I think are self-explanatory, but I would like to invite any member of the council to speak on any of the council amendments that they'd like to speak on. So let's start with the first council amendment, which appears on line 4 through 5. It would strike the language that appears on the screen and also in your markup. So the sentence would conclude with AI also raised concerns about the absence of human decision-making, period. Let me turn to Ron Cass in the first instance to see if he has any comments on that explanation or elaboration of that amendment. Ron, let me turn to you. And then if there are other council members who wish to be heard, I'll be happy to recognize them after Ron. Ron?
First of all, I think it's a terrific project and a great report and recommendation. And I'm glad that everyone was able to work through Thanksgiving and not produce a turkey, which would be the usual outcome. A lot of the council amendments, I think, are reflective of the sort of modern language versus old-fashioned language. And a lot of times we're contrasting what happens in AI with what happens with human decision-making. A lot of the council amendments are trying to find a different formulation for saying that, because there's obviously human decision-making that goes into AI. The way it's framed, the way it is laid out, the way it's programmed, all requires a certain amount of human decision-making. So what you have in the first recommendation, first proposed amendment, and in a number of other proposed amendments from the council are ways of just reflecting that we're contrasting individual human decision-making or human decision-making unaided by machines or unaided by this sort of machine process with the sort of processes we're talking about here.
Thank you, Ron. With respect to the first council amendment, John Cooney, do you have any comments on that as the committee chair? And if you don't, do any of our consultants?
This is David Engstrom. I'd like to be heard if once John has spoken.
John, do you want me to just turn to David first? I'll recognize David Engstrom first, and then we'll come back to John to see if he has any comments. David, please.
Thanks, Matt. With due respect to the council, I really dislike the use of the word absence here. The concern when we're thinking about the use of various ML tools by government agencies is not typically the absence of human decision-making. In fact, there's very little, if any, fully automated decision-making that we found within the federal administrative state. I think that's true across government and other levels as well. Rather, it's displacement of discretion, and that displacement is partial. It's that a central data analytics group hands off some machine outputs to an agency official, often a line level one, and that line level person can rely on the output or be made to rely on that output to a greater or lesser extent. So in other words, I worry here that absent suggests a binary, but displacement actually exists along a continuum, and partial displacement is both more prominent and still worrying. And so I don't think I'm allowed to propose amendments, but I might recommend that the conference move towards replacing absence with some language that just basically says the displacement of human decision-making and exercise of discretion. That strikes me as a more accurate accounting of what our real anxieties are here.
So tell us what you propose.
Just say also raises, but agencies' use of AI also raise concerns about the displacement of human decision-making and exercise of discretion. Again, I think displacement captures this continuum idea rather than suggesting that the concern is the complete absence of human decision-making.
This is Carrie. Matt, if I could add a friendly amendment to David's?
Yes, please.
If you wanted to, thank you. If you wanted to, David, you could say full or partial displacement.
David?
Sure, I like that. Again, that captures the continuum notion, the idea that partial displacement is both more pervasive and in fact might be the only type of displacement and is still worrying and should concern us.
John Cooney, do you have any comments on the council amendment in its original form or as it's been revised? John?
sorry, I was muted there. I like the concept of displacement as opposed to absence. Displacement is a description of the process that has gone through, and absence states the end condition. So I like that concept of displacement. It gives the reader a better sense of the dynamic.
Am I muted? I just have a note here that says I'm muted. No? Okay. Ron, do you wish to be recognized? Ron Cass?
Yes. Thank
Please.
you. Actually, the note was to John Cooney that he was muted.
Okay.
I think the recommended change here is an improvement on the council recommendation. I don't believe I can speak for the council, but if I could, I would say that I would embrace the changed version of this amendment.
Well, let me ask if we don't have a set parliamentary procedure with dealing with situations like this. So let me just ask the council if there are any members of the council who disagree with Ron and would like to stand on the original council amendment, in which case I will take a vote on that. Jennifer Dickey, please. Jennifer Dickey is recognized.
So one concern I have with this, the reference to exercise of discretion, is whether we're suggesting that it's the partial displacement of the exercise of human discretion, or we're suggesting that the AI is exercising the discretion. I found that confusing in the proposed changed language. I'm fine with full or partial displacement of human decision-making, or even full or partial displacement of human decision-making and discretion, or something to more clearly indicate whether the exercise of discretion is referring to human exercise of discretion or the exercise of discretion by the AI systems.
That's a good point. May I turn back to you, David Engstrom, to respond?
Sure, I like that proposal. I think just removing exercise of brings discretion into closer proximity to the word human, and I think eliminates some of the ambiguity that appears to be a concern.
So do we have the language as it should be on the screen? Jennifer, let me just turn back to you, Jennifer Dickey. Are you happy with what appears on the screen now?
Yes, I'm fine with that.
Okay, are there any other council members who have any comments on this language here? Or I should say the amendment to the council amendment? Hearing none, let me ask the membership if there's any objection to the council amendment as amended, as it appears in lines 4 through 5. All right, without objection, that amendment is adopted. Now we'll turn to the next council amendment, which appears on line 53 of the red line in the packets. I don't know if, I assume the page numbering has not yet changed, or has it? Yes, it has not. Or is it in, it's on line 52 now? Okay, so the council amendment is on line 52, and it relates to footnote number 4, and it would strike the last clause of footnote 4 that reads, especially those implicating concerns related to fairness and equal treatment. Are there any council members who wish to be heard on that council amendment? Ron, Jennifer, others? Jennifer, please. Jennifer Dickey is recognized to speak to the second council amendment. Thank you, Jen.
I think the concern here was that the clause saying especially those implicating concerns related to fairness and equal treatment was a little bit vague as to its subject, like when are systemic errors in decision making particularly related to fairness and equal treatment, as opposed to just generally related to fairness and equal treatment. I think as a general matter, common or systemic errors in decision making do raise concerns about fairness and equal treatment. So I wasn't sure what benefit we were gaining from that clause, and I thought it might be implicating or like might be creating vagueness in the sentence.
John Cooney, do you want to speak to the council amendment? And if when you're done, I'll turn to David Angstrom and any of the other consultants who wish to be heard on that. John?
I would prefer to defer to people who have a working understanding of the use of the term bias in AI.
Let's turn to on this one to Dan Ho, and then if there are other consultants who wish to be recognized, I'll recognize them. Dan, do you have any thoughts on this? If I may put you on the spot.
Yeah, I realize the purpose here of footnote 4, as I understand it, is really to try to distinguish the use of the term bias in statistics from the notion of demographic forms of bias that have been of particular concern with the adoption of AI systems. I actually think the first part of this footnote is actually also a little bit confusing. So I don't know if it would be possible to suggest a kind of simplification here, just to make this much clearer. I would suggest something like, while the term bias has a technical statistical meaning, and then I would just get rid of everything here, starting until the administrative conference. I think that would just simplify the kind of distinction between bias used in the statistical sense, which is like, does the statistical estimate actually approach the target population quantity? You know, I don't think we need to get into that. I think this would suffice to give the reader a sense that we're not using bias in kind of a technical sense.
If I may put the council on the spot, does the council consider the proposed language that Dan just gave us to be a friendly amendment to the council amendment?
I'd be happy to speak to that.
Ron Kask, please, and then if Jennifer has any comments, we'll turn to her.
I would consider that a friendly amendment.
Jennifer, may I just put you on the spot for a second, since you perceptively identified this problem in the first place?
Yeah, I think that's a friendly amendment.
Okay. Are there any other council members? Are there any council members who wish to stand on the original amendment? Is there anyone, Ron, can I treat this as a CAS amendment? We'll treat this as the council amendment, excuse me. We'll treat this as council amendment 2. Does anybody else wish to be heard on the council amendment? Is there any objection to the adoption of the council amendment? Council amendment number 2. All right, without objection, council amendment number 2 is adopted. Now we'll turn to the Reeve, what do we have next? A comment from the council?
Yeah, 66.
All right, so we have a comment from the council at lines, it's 65 through 66 on the version that's now on the screen, and it's line 66 through 67 on the red line in the packet, right? All right, the comment from the council requests clarification from the committee as to what it means by population. John, I can turn to you first, and if you'd like to turn to one of our consultants, we can certainly do that. John?
Again, I'll defer to the consultants for the meaning of this term, population in the AI world.
Does one of our consultants wish to speak to this issue here?
I'm happy to speak to it. I think the idea here is
this is Dan. Dan, let me this is just all for our record here. Dan Ho is recognized.
Thank you. Sorry about that. So I think the idea here is that oftentimes you can have an AI system that performs accurately for one part of the population and not so well for another part. So for instance, if the Internal Revenue Service is building out a system for tax enforcement, it might work really well for higher income taxpayers and exhibit more errors for lower income taxpayers or the reverse. So that's sort of what I think this language is trying to point to.
Is there a better way to, is there a word other than population that might satisfy the council's concern here?
Matt, Carrie Colonisi, could I be recognized?
Carrie Colonisi is recognized.
I think that, you could simply say set of individuals in both places where population is used here, or even just set next to in the next use, set of individuals in the first use and set.
Anyone on the council wish to be heard on the response from Dan and then Carrie? Jennifer, did you wish to be heard? I'm just want to make sure.
I just had a follow-up question. So is the idea with set of individuals, that's indicating that we're always speaking here about a population of humans? That was the confusion I had. Sometimes I think population is referred to other types of data, and I wasn't sure if in AI systems there's other sort of data that's being used that's not like about a subset of a human population, but other population of data. And so that was the sort of question. I think if we are in fact talking about data about particular parts of the human population, then I think this language clarifies that. I just wanted to make sure that that is in fact what we're talking about.
This is Dan Ho. May I be recognized?
Dan Ho, yes, please.
Yeah, I think, Jen, that's a really valid concern. My worry here is that there are AI systems that are, for instance, about weather forecasting or underwater mapping, where the population does have a kind of technical clarity to it that coheres with the machine learning literature. If you're trying to draw an inference or a prediction about some population of interest, that does not necessarily have to be human beings. So I don't know what a better refinement is. One could say something like affects a particular population of interest, but information about that population is not directly available.
This is David Engstrom. Could I be heard?
Yes, David Engstrom, please.
So I guess I feel that we should move away from population, which means something very distinct in statistical terms. We often distinguish a population from a sample, which is drawn from a population. And so I worry that including population just muddies things unnecessarily. As a friendly further amendment to set of individuals, which I think would work quite nicely, why not say a group of individuals or a group? That seems to me to be a plausible alternative. The one last thing I'll flag is that I think fairly read this sentence, at least by agency officials who are consuming it, might think this is talking about algorithmic bias and therefore a very particular type of bias as directed against demographic or social groups. So I guess query whether we would want to make some mention of that, even if it's query whether we might want to make some mention of that. Else we have a statement here that seems to scrub one of the most salient concerns about AI use, at least in the public imagination, I would think, which is that algorithmic bias on the basis of social or demographic groupings.
Does anybody else wish to be heard on this point?
Matt, if I may, this is Kerry Colonisi.
Carrie, please.
To address Dan's earlier point, one could change it to set of individuals or individual cases or individual instances. I think that could account for, instances of weather or some such.
Instances of what? Is there a word missing there? Individual instances?
Matt, this is Kathy Sharkey. I don't know who proposed it. Dan, I think it was your word. I think using the word group might be better. Because it's simple.
Kathy,
Yeah.
just hold it. I'm just trying to preserve a record here. That's why I'm interrupting. Kathy Sharkey is recognized.
Great, thanks. Sorry about that. I think Dan originally proposed a slight amendment that didn't get reflected, but I liked the word group. Just substitute group for population, and I think it works and it doesn't get so complicated. And those in a group could be individuals or entities.
Does someone who has a vote and who is not recused, and several of our consultants are recused, wish to move an amendment here? Could be from the council or otherwise. Ron Cass, please.
Yeah, I would move. Thank you. I would move the council amendment. I would be happy to take group in place of population, but I think we need something in addition to that, because if we say, but information about those in that group, it suggests that we're talking about people. I think that would be the natural reading that is given to it, certainly by those of us who don't deal with this information all the time. And if someone can suggest an additional term, I think it would be helpful, whether it's a group of individuals or entities or characteristics, whatever. I think we need one more term to make sure it's clear that we're talking about something more than just individuals here. And I don't know whether Carrie or Dan or David has a suggested additional term, but I think it would be good to add that.
Dan, Kathy, or Carrie, and do any of you seek recognition to address Ron's point?
I'd like to be recognized.
Dan Ho, please.
So Ron, I think that's a good point. What I would propose is to change "but information about those in that group" to "but information about group membership is not directly available." This is really responding to something we've heard in a lot of these discussions about AI oversight, about how hard it can be to assess for forms of bias in AI systems when group membership is not available.
I'm going to recognize Jennifer Dickey now. Jennifer?
I was wondering whether it could simply say affects a particular group, but information about that group is not directly available. Like be a little more generic information about that group without identifying group membership in particular, because membership could still like trigger like human members of a group.
Dan?
This is
or David Engstrom.
Sorry, yes, thank you, Matt. A further possibility might be to say information identifying members of that group.
Let me turn back to Jen Dickey, please.
That I guess that changes the meaning. That makes this say something that I had not realized it was saying. So challenges such as when the bias affects a particular group, and we know it affects a group, but we don't know the members of that group. Like, I'm not an AI expert. I read that. I wonder whether this is saying, like, we don't know who's, like, this bias affects a particular social group, say like Hispanics, and we don't know who are Hispanics. Like, I guess I don't understand. Like, I would think that the problem is that it's affecting the Hispanic groups, not that you don't know who's in that group. I guess, so I'm confused by, I'm confused. I apologize.
Could I be recognized? This is Dan Ho.
Yeah, Dan Ho, please.
Yeah, I think this section is trying to do both. And what we've heard from a fair number of government agencies is that oftentimes they don't have that information available even to be able to understand whether an AI system has differential impact. And so this whole section, I think, is getting at both of those notions. When group membership is available, is there evidence for differential impact? And if it's not available, there may be other ways in which to still gain some understanding of the impact of the AI system.
James Ming, James Chen, excuse me. Jim Chen, do you wish to be recognized on this issue?
Yes, please. Just a
Please.
commentary on what it means to identify members of a group in an AI context. I just spent 2 years getting a degree in the subject. And I will say from that experience that the paradigmatic example is natural language processing that says, queen minus man, king minus man plus woman equals queen, which is a great AI insight, but doctor minus man plus woman equals nurse is algorithmically biased, right? That's the classic example of that. And when you limit information identifying members of the group to this particular formulation, I think omits the possibility that you have bias even without identification of a group. So if I may just on the fly suggest, right, as when the bias, as when the bias affects a particular group, that's fine, right? But information indicating the source of bias is not directly available. And that way, we don't have to say whether it's the group or whether it is a flaw in the algorithm. The natural language example I gave is simply because if you draw from older samples of language, quite often the algorithm will infer that doctors are men and nurses are women, which is a sociological reality from many decades ago. But to impose that in a natural language setting is a problem. And it's not about the members of the group. It's actually a flaw in the algorithm or in the data that you feed it. So I think if you simply say the source of bias without focusing on the group, that this might be a helpful change. And I offer it as without hostility to any of the discussion that's gone on so far.
Does anybody wish to be heard on Jim Chen's suggestion here on line 65 through 66? Let me ask first if any of our consultants wish to be heard. Let me turn to Dan Ho and put him on the spot. Dan, what do you think of Jim Chen's suggestion?
I think the proposed language makes this a little bit more complicated because in a lot of the literature on algorithmic bias, actually understanding the source of bias can be very complicated. So I still really like the more limited point here about trying to understand something or pointing to the lack of information about the subgroups of interest. So that would be my preferred way of stating it. we have tons and tons of scholarship that is trying to understand the sources of bias, and it can be decomposed into lots of different sources. Bias in the outcomes of interest, bias in the representativeness of the sample, and et cetera, et cetera. And so I think this opens it up to a range of other concerns rather than the more precise one about the lack of demographic information or group membership information.
Any of our other consultants wish to be heard on Jim Chen's suggested language?
Matt, if I may, this is Kerry Colonisi.
Kerry, please.
You know, the entire second clause here that we're working on is intended, as I read it at least, as illustrative. Identifying harmful biases in AI systems can pose challenges, comma, such as when, do we need, you know, I agree with Dan, there's a lot of complexities here. I'm not sure anything that follows in this paragraph or in the statement really depends upon this particular manifestation or understanding or characterization of bias. This wouldn't be, I guess, a friendly amendment, but it would, I think, resolve all of the concerns, which would be just to end the sentence at the comma and delete everything else, and you know, which I think would follow quite nicely, and leave it to other. The point of the ACUS recommendation, it seems to me, is not to catalog all the potential challenges related to bias with AI, but to alert agencies to the existence of such challenges and some general, you know, recommendations to try to identify and mitigate those biases.
So Kerry, just to clarify, what are you proposing exactly?
Just delete everything after the comma.
And then it says and then it'll say identify harmful biases in AI systems, and then the next sentence was.
And then you would eliminate the word such, perhaps. You could just, to identify and mitigate biases, agencies should, to the extent practical, consider whether other data or methods are available.
Matt, this is Kathy Sharkey. Can I be heard?
Yeah, Kathy Sharkey, please.
Yeah, although I'm reticent, Kerry, I typically want to cheer your simplifications. I feel like that. I feel like the second sentence becomes quite cryptic then. I liked how Dan's proposal was keeping kind of this idea of we're urging agencies to consider other data and methods, specifically because of the bias with respect to how we have a group, but not, as he pointed out, through interviews, et cetera, not information coming from the agency. Although I see that Ron and Jennifer disagree. Just to me, it seems very vague to say can pose challenges, and then to identify and mitigate biases, we're proposing the following.
Okay, we'll turn to, I'll recognize Ron Cass and then Jen Dickey. Ron, please.
Thank you, Matt. I like the proposed change by Kerry because I think we're getting into a level of complexity and trying to figure out what the biases are, whether they're in the composite, identifying the membership of the group, characteristics of the group, the way the group is being treated by an algorithm. And I think the more we try to explain that, the harder it's going to be for people using this particular recommendation to see the point. I would stick with the more general point and then let the other parts of the recommendation pick up particular applications of it.
Okay, let me turn to Jen Dickey. Jen, please.
Yes, I agree with Ron that we're getting a little complicated. The sort of question that led to the council comment was that population was kind of vague, and were we talking about humans? Because the most common sort of systematic bias we think about is, you know, bias towards particular population groups. But then we've already suggested, or the consultants have indicated that in fact this could also apply to non-humans, to instances, and every sort of suggestion we've tried, I think, has failed to capture all of those factors. And so I would be inclined to just ended at, identifying harmful biases in AI systems can pose challenges. And that way we don't sort of, in our own way, bias agencies to be looking for one type of bias, but not another.
So the sentence would now, the amendment would be to, the amended language would read, identify harmful biases in AI systems can pose challenges, period. And then we go on to the next sentence, to identify. Is that correct?
Yes.
Okay. Is there among voting members? Does anybody else? Are there any members other than our consultants who wish to be heard on the tinkering we're doing with lines 65 through 67? All right. I'm going to refer to the amendment on lines 65 through 67 as the Cass-Dickey Amendment. Is there objection to the Cass-Dickey Amendment? All right, without objection, the Cass-Dickey Amendment is adopted. And do we have that correct on the screen? And yes, Ron, we will delete such in the next sentence. I think Mark's already done that. All right, do we have that up correctly? So we go now to Reeve. What do we have next by way of? We have one. We have.
Comments in the original lines 137 through 139.
All right. So let's go to the. Let's go to the next council comment. Do we have that up on the screen? That risk. Now it's lines. The council comment relates to the lines 135 through 137 on the version that's on the screen, and 137 through 139 in the red line in the packets. The council comment is the council requests clarification from the committee as to what is meant by tolerable. Does it mean legally tolerable, tolerable in terms of public perception, something else? May I turn to John Cooney in the first instance to address the council's request for clarification? John?
Thanks, Matt. Again, I think we'd be better served by somebody familiar with the AI world who knows whether tolerable was just used here in its generic sense or whether there's it's a term of art in the AI business.
All right, so let me start. Let me ask Dan Ho if he has a comment on this that he wishes to share, and then I'll turn to David Angstrom and then Kathy Sharkey. Dan?
I don't think this was used in any technical sense.
Okay. David Angstrom?
I agree. Yeah, this is not some special term of art. So it could mean legally, it could mean policy analytic. I'm not sure, but I think there are probably ways to recraft the sentences or sentence to include both conceptions.
Kathy, do you have a comment here on the council request?
Yeah.
Does anybody have a proposed amendment in response to the council's request for clarification?
Matt, this is Carrie, if I may.
Carrie, please. I'm sorry, I skipped you, Carrie. Please, Carrie Colonese.
There is a use of acceptable risk in the world of risk analysis and risk management that may be more precise here. I think that this means acceptable in any variety of senses, whether it's legally, morally, in terms of public perceptions. I use in the consultant's report public acceptability, so there is some connection at least with that portion of the report.
Ron Cass, may I turn to you to see how the word acceptable and unacceptable sits with you?
Well, since I just sent out a message saying we should use acceptable and unacceptable, it sits fine with me. I think Carrie had a terrific idea, and I second the idea.
Do you move it as an amendment?
I do.
All right. I'll call it the Cass Amendment. Is there any objection to the Cass Amendment? Without objection, the Cass amendment is adopted. Now we'll move to the next proposed amendment from the council, which appears, do we have that up yet? Not yet. It appear, I can't, I'm having trouble seeing the screen here.
Lines 145, 146, I believe, adding in a more traditional manner without reliance on.
Is there a member of the council who wishes to speak to that amendment?
Matt,
Jennifer Dickey is recognized, and then Ron Cass.
I think the point here was simply to pick up on the note elsewhere in this statement that in fact, obviously human beings are choosing the AI systems. And so to suggest that decisions made by AI systems are like wholly divorced from decisions by human beings is perhaps not consistent with what the rest of the statement says. And so this just is trying to pick up on that that distinction again, that agencies may wish to have decisions made by made in a more traditional people in a more traditional manner, but like obviously if they're using AI that human beings have selected, that's also decisions in some sense being made by human beings.
Ron, did you wish to, thank you, Jen. Ron, did you wish to be heard on this?
nothing to add.
Does anybody have any comments on the council amendment?
This is David Engstrom. I have a brief comment.
David Engstrom, please. You're recognized.
I'm not sure about the phrase in a more traditional manner. I might favor dropping that and just saying without reliance on AI techniques. I also wonder about the notion of a decision made by people. So in some cases, agencies are choosing to deploy machine learning, and what it's replacing is more conventional econometrics, you know, sort of basic linear regression of the sort an economist would do. And so I might take out the people and I might take out the traditional manner and simply go made without reliance on AI techniques.
How does that sit with others, including and especially the members of the council? What David has just proposed.
Matt?
Yes, Ron?
I'm fine with that.
Jennifer, can I turn to you if I may?
Yes, I'm also fine with that.
Okay, are there any other members of the council who have concerns with the amendment to the council amendment that David Engstrom just suggested? Any objection to the council amendment as rephrased? All right, without objection, that council amendment is adopted, and we now have that, or will in a second, have that reflected on the screen. That's perfect. Thank you, Mark. The next council, we have another council amendment number 4, which appears in lines 146 through 49, and the council amendment would strike the phrase after the comma beginning with "and AI systems may be difficult." Are there any members of the council who would like to be heard on that amendment, proposed amendment? Jen, can I turn to you?
Yes, so I think the decision here, or the suggestion, was to avoid making a normative judgment where we had the sort of draft said like AI systems may be difficult to sustain if human beings perceive them. It could be viewed as like a normative judgment or even a predictive judgment about what agencies may experience. And instead, we just wanted to stay more neutral, that they may wish to consider whether people would perceive the systems that way.
Thank you, Jim. May I turn to the committee chair and consultants for reaction to this council amendment number 4? John, do you want to defer to the consultants, or do you wish to speak?
I'll speak quickly, just as a matter of thinking about the ignorant reader coming through this for the first time, I think the proposed council amendment will simplify the thought process and again eliminate something that may that seem to be going down a path that we don't end up pursuing.
Does anyone else wish to be heard on the council amendment number 4? I think we have a consensus here, but before I declare one, let me just give everyone another minute, another second or two. Is there any objection? Is there any objection from voting members to council amendment number 4? Without objection, council amendment number 4 is adopted. Is that the end of our council amendments? Thank you very much, and especially Jen for articulating the council's views so articulately and clearly, and also to Ron. So with that, now we're going to turn to the other pre-submitted amendments. I think Jack Biermann has an amendment to line 6, which I think may have been rendered moot by the council amendment. So I'm going to move on to the next amendment, next pre-submitted amendment, excuse me. And that is the comment from Jeff Lubbers. So Jeff, Mark, if you've got her, you're already ahead of me here. Jeff Lubbers has a comment about the role of the Paperwork Reduction Act in this context. Jeff, you're recognized.
Thank you, Matt. I just, when I read the next paragraph on privacy, there were a lot of mentions of the Privacy Act and other related statutes, but obviously when agencies collect data from the public, they have to follow the restrictions in the Paperwork Reduction Act. So I just wondered whether the consultants and the committee had considered whether they should say something about the Paperwork Reduction Act here. I don't feel strongly about it, but.
Any thoughts from the first John Cooney, and then I'll turn to the consultants. John?
I wonder if there's anyone with the group who has experience with how the courts have interpreted the application of the Paperwork Reduction Act. When you're talking about big data, almost by definition, it sounds like you're talking about a background gathering process that somebody has gone through.
Any of our consultants, would any of our consultants like to be recognized?
I'd like to be recognized.
Dan Ho, please.
I think there's a citation to the Paperwork Reduction Act in the privacy section. I think it's in footnote 8. So it is alluded to here, if not specifically textually discussed.
Jeff, anything further on this?
Well, not really, although that's in the privacy section, and maybe the footnote should be in the data collection section.
Matt, this is Carrie, if I may be recognized.
Carrie, please. Carrie Colonese.
If you wanted to include a reference to it, perhaps the last sentence where agencies should review and consider statutes and regulations that impact their uses of AI as a potential, perhaps you add the word there, as a potential collector and consumer of data, and then put a footnote to the Paperwork Reduction Act at the end of that sentence, CEG.
Jeff, what do you think of that, Jeff Lubbers?
I like that. I like that.
All right. Well, is this John Cooney? Can I turn back to you? Are you on board with that amendment?
Yes, that seems to address Jeff's concerns in a very nice way. It adds explicitly the collection aspect of data, and by the citation of the Paperwork Reduction Act, it tells the informed reader exactly what we're focusing on, but does it in a very efficient way so we don't have anything further in text that might needlessly expand the scope of what the statement says.
All right. Well, none of you can offer an amendment, but I think that I'm able to, and I will offer amendment line. I'll just call it Amendment 109. Is there any objection to Amendment 109? All right, without objection, Amendment 109 is adopted. Now we move on to Jack Biermann's pre-submitted amendment on page 7, the section on security. Jack, you are recognized to discuss your proposed amendment.
Yeah, I think it's pretty self-explanatory. It's just the idea that one of the security risks would be that the system could get hacked into, which wasn't mentioned.
All right, this is an area I think in which we need to draw on the technical expertise of our consultants. Do any of our consultants wish to speak to Jack's suggestion that the word hack be included on line 120 now? Someone must have a thought on that.
This is David Engstrom. I can offer a thought.
David, please, David Engstrom, please.
I think it's a nice expansion of the list of concerns. All the others in the list skew more towards gaming and adversarialism, and I think hacked brings front and center the basic cybersecurity concern. So I like the addition.
Do our other consultants like the addition? Dan, Carrie, Kathy?
Yes.
Yes.
All right, everybody likes the addition. Is there any objection to the Biermann Amendment on line 120? Without objection, the Biermann Amendment is adopted. And now we turn to the next pre-submitted amendment, which comes from our government member, Stephanie Tatham from OMB, who represents OMB. Stephanie, you're recognized.
Thank you, Matt. Thank you for the opportunity to participate in the ad hoc committee where I was joined by Jonathan Hill of OIRA's Legacy Branch. In the last committee meeting, we saw some new language in the issue areas of security and oversight, and Jonathan and I thought that it would be helpful to highlight for agencies a few government resources that may be useful to consider in this context. This language is not intended to be prescriptive. So here in the security section, we added text noting that the risk management framework discussed earlier in the privacy section is also a tool for agencies to utilize in addressing security risks. We suggest a footnote to the same resources discussed in the privacy section, specifically NIST privacy framework and risk management framework, as well as OMB Circular A130 concerning managing information as a strategic resource. Just a technical note, if possible, we ask the Committee on Style to update footnote 11 in the red line to refer back to footnote 9, as we submitted our comment on a draft that did not contain what is now footnote 10. So that's our first amendment. I'm happy to speak to my second or to wait to a more appropriate time.
Steph's amendment is to add the sentence in lines 130 through 131. Do any of our consultants wish to be heard on Stephanie Tatham's amendments to lines or to add an additional sentence at the end of the paragraph on security?
This is Carrie.
Carrie Colonnese is recognized.
I think the addition of the reference is valuable, and I guess I don't know that I see the need or the value added by a full sentence in the text. Could the citation simply be added to footnote 11, where the statement as drafted already indicates that agencies should consider using various frameworks developed already? Or should we just maybe reword that sentence to be more general to include the risk management framework?
Well, where does the footnote 11? Oh, I'm sorry, it's 12 now. Okay.
Yeah, the way it begins too, the risk management framework, it seems to just leap out. And for me as a reader, at least, I'm not sure I would know really. The article "the" connotes some degree of familiarity with what follows. So if it does deserve a separate sentence all on its own, I would suggest just some stylistic rewording of it, but I'm not sure that's really even needed. I would think that it could be accommodated by adding the citation to footnote 11.
Stephanie, may I turn back to you and ask what you think of Carrie's suggestion that the point be addressed by the inclusion of a citation in footnote 11?
That's acceptable to me. I think that's a fine alternative. The one tweak that I would make at the end of the sentence that Carrie would be moving the reference into is I'm not sure that OMB Circular A130 can be described as a relevant voluntary consensus standard and framework developed through open multi-stakeholder processes. So perhaps just adding and consider using relevant, and then at the very end of that sentence after processes and guidance, government guidance or something similar.
Mark, is that clear to you?
So Mark, after processes,
Steph, just repeat that slowly so Mark can get it up on the screen and everybody can see it.
Yes. After processes, please insert and government guidance.
This is Carrie. I think that's a great idea. I wonder if just stylistically, it would make sense to refer to government guidance first, using relevant government guidance or voluntary consensus standards and frameworks developed through.
Stephanie?
Sure, absolutely.
That's okay with you?
Yeah, and we'd be happy to include, for Jonathan, your suggestion to me, a reference also to the new OMB memo, M2106 on guidance for the regulation of AI applications. If folks were amenable to including that.
Just pausing here while Mark puts this up on the screen. Stephanie, just look at the screen and tell me if your amendment number 1 as revised appears as it should appear.
Yes, and then I believe we have the suggestion in the chat of adding a new government guidance document.
I don't want to
recently.
What is the suggestion in the chat? I don't want no substantive suggestions in the chat. Let's put this on the record here.
Yes, the suggestion is to include in the footnote a reference to OMB memo M2106 on guidance for regulation of AI applications.
Mark, could you just put a notation to that effect? Steph, does Tatham Amendment number 1 appear on the screen as you would like it to appear?
I'm having trouble seeing the footnote in the Zoom. Does OMB Circular A130 also appear?
Read the footnote, Mark, just please. Is Mark on? Is his audio on? Okay, go ahead.
It says CEG, National Institute of Standards and Technology, Risk Management Framework for Information Systems and Organizations, Footnote 9. Then we are going to add a reference to M2106, the OMB memo on regulation of AI systems. And then there's a citation to also the National Institute for Standards and Technology, their framework for improving critical infrastructure cybersecurity.
Yes, so the Supra Note 9 should encompass also the reference to the Office of Management and Budget Circular A130. So as long as that's understood, I think that we're good. And apologies for mucking around in the footnotes.
Just tell me, Mark, when you're satisfied. Yeah, I know. Don't apologize. As it crashes.
Matt, it's Kathy Sharkey. I have a very small stylistic tweak about this footnote.
Just hold on 1 second, Kathy, and we'll get to you. All right, our screen is just frozen here, so, or Mark's screen, I should say. It's not my screen. We're just going to pause for a moment here while we attend to this little computer glitch. Now? We're going to take a 5-minute break and resume at, when is that?
3:21.
We'll resume at 3:21, and hopefully during the break that we can address this problem. And staff, please be on deck for your next amendment, Tatham Amendment number 2. Thank you.
Okay.
5, 2.
All right, we're back. We're going to, so I apologize for the delay. I don't know what the problem is, but it's been corrected. We're going to hopefully bring this discussion of Tatham number 1 to a close. Steph, the text on the screen is written as you would like it to be written. Yes?
Yes.
Okay. Is there any objection to Tatham Amendment number 1? Without objection, Tatham Amendment number 1 is adopted. We'll now move to.
Sorry, Matt, it's Kathy Sharkey. Could I raise one issue that I think we should address right here?
Okay.
It's very quick. It's just footnotes 9 and 11 and the text preceding them were designed to be parallel. So I would propose adding the relevant, the language about government guidance in the text leading up to footnote 9, because it likewise cites an OMB document and NIST frameworks. And I also, the same way the committee talked about the sources in 10, grouping together NIST and then following by OMB, I would do that in footnote 11, as opposed to having the OMB come in between the two NIST.
Can we remit that? Kathy, do you see any reason we can't remit that to the Committee on Style?
Okay.
Unless there's is there a voting member who wishes to move an amendment here? All right. Stephanie Tatham is recognized on her second amendment.
Great. So very quickly in the oversight section, we suggested some additional factors that agencies may wish to take into account as they develop internal evaluation and oversight mechanisms for their AI systems. So you can see those on the screen. They are agency system level risk management, authorization to operate, continuous monitoring responsibilities, and their broader enterprise risk management responsibilities. We also suggest inclusion of a footnote referencing OMB Circular A123, which covers agencies' management responsibility for internal control in federal agencies.
Let me turn first to, is that it? Stephanie, thank you. Let me turn to John Cooney, the committee chair, for any reactions he may have to this amendment. John? Any of our consultants have any reaction to this amendment? No? Is there any objection to the adoption of Tatham Amendment number 2? And I'll give you a few minutes to key in an objection if you have one.
Matt, it's Kathy Sharkey. I have one small point.
Okay, Kathy's recognized.
Yeah, so just throughout, there were things where continuous for monitoring was changed to regular. Again, I don't know if that's a stylistic thing, but people raised that in various committee drafts.
That should have been addressed as a council amendment, correct? Or a, Matt, it was already addressed, Kathy, as a manager's amendment, correct?
It is well taken. I will amend my amendment to.
Not in the, all right, so not in the, so Stephanie, we're going to put the word regular into the Tatham amendment. No objection from you, right?
No.
Okay, so the Tatham amendment is adopted with the substitution of regular for continuous. And thank you, Kathy, for pointing that out. I appreciate it. Are there any, that concludes the pre-submitted amendments, our consideration of the pre-submitted amendments. Are there any amendments from the floor on this statement before we turn to a vote on it?
Matt, John Cooney, may I be heard quickly?
Yes, John.
I've received a note from Warren Belmard. Warren asked us to look at line 51 of the current text. At the end of that line, there's a reference to reducing the impact of unwanted biases. And Warren questions whether the word unwanted should be included and recommends it be taken out on the theory that there is no such thing as a warranted bias.
Where is, I don't see, is Warren on the phone?
I don't believe so. I received this by text message. He must have been listening, but I have not heard him on this call.
All right, is there a voting member who wishes to move an amendment, who wishes to strike the word unwarranted?
I'm sorry, it's unwanted. I misspoke.
Unwanted, excuse me. Kristen Hickman seeks recognition.
Sorry, I guess I'm going to follow up just with a question from the experts on this as to whether there would ever be a wanted bias. Because otherwise, I think the point is well taken, but I don't know enough about the subject to feel confident saying that there would never be a wanted bias.
Do any of our consultants wish to respond to Kristen Hickman?
This is Carrie.
Carrie Colanese is recognized.
Thank you, Matt. I think, first of all, it's a much broader amendment if it were to be made or proposed, because the whole section is called harmful bias, and throughout the recommendation, there is always an adjective in front of bias. And it's there, I think, primarily for a reason. There may be instances in which algorithms are adjusted so that trade-offs between, let's say, accuracy and impact on certain groups is adjusted so that there is some bias, but maybe bias, for example, away from accuracy and in favor of what might be thought of as principles of social justice or fairness. So I think the adjective is important. If unwanted seems awkward, or perhaps it should be changed to harmful, the same title as the section and the same adjective that's used elsewhere in the statement in front of the word bias.
All right, let me recognize, thank you, Carrie, that's very helpful. I'll go back to the other consultants in a moment, but let me recognize John Kaminsky. John?
Thank you very much, Matt. I just want to reinforce what Carrie said. There are instances where there is wanted bias in statistical terms for different data sets, and for the same reasons that Carrie mentioned. There's a report that the National Academy for Public Administration will be issuing on Friday that has a specific case example of that.
Let me turn to Ron Cass and ask him about the word harmful. I think he seeks recognition. Ron? Ron?
Can you hear me now?
We can hear you now.
Great. I was recommending that we use the word harmful here instead of unwanted. It conforms to the title and to our uses elsewhere in the recommendation. And I don't think it does any violence to what is being proposed, although I stand ready to be corrected on that if the experts have a different view.
I was, maybe it's getting late in the day, Ron. I was concerned that you were going to say is that harmful could be harmful, but I'm glad that you are on board with that. All right, so let me turn back to Kristen on the point. Kristen, you're recognized.
Sure.
Kristen Hickman.
On the assumption that harmful fixes Warren Belmar's concern, it certainly seems to fix mine as well. So I support and move or whatever the amendment of instead of unwanted, replacing it with harmful.
All right. So now this is going to be the Hickman amendment, because Warren Belmar can't move an amendment as a senior fellow. Plus, he's not I don't believe he's on the Zoom.
I'm back on the line.
Oh, you're back on the line. Warren, did you want to be heard briefly? And it would have to be very briefly.
I'm happy with the solution, and I think that makes it much more understandable to the public.
Okay, thank you. So is there any objection to the Hickman Amendment, which would substitute the word harmful for unwanted? All right, without objection, the Hickman Amendment is adopted. Are there any further amendments on the proposed amendments to the recommendation? To the statement, excuse me. Okay, we'll proceed to a vote. We're going to do a voice vote. If you'll unmute yourselves. Tell me when I'm ready. Go ahead. I'll give you. Okay, all those in favor of the adoption of the statement, please say yay.
Yes.
Yay. Opposed? The yeas have it, and the statement is adopted. And now we're going to proceed to our fourth and final recommendation for the day. And we're going to do this one a little bit differently. I have to recuse myself from this recommendation because I was one of the co-consultants. And so I'm going to turn it over to Ron Cass with my sincere thanks for presiding over this part of the plenary session. What do we need to do now? We would like another 5-minute, if you'll indulge us, we'd like another 5-minute break just to shift course here and turn the gavel over to Ron. So we'll resume in 5 minutes. That's good, right?
Yeah.
Okay.
Welcome back. Our next recommendation is Agency Appellate Systems, which comes to us from the Committee on Adjudication. I'd like to thank Nadine Mancini, the chair of the Committee on Adjudication, and Chris Walker and Matt Weiner, who served as project co-consultants. Matt having taken off his glasses to reveal that he's not actually Clark Kent, but Superman. We'll hear from Chris on the report and then Nadine on the committee's proceedings, and I'd like to recognize Chris Walker.
Great, thanks so much, Ron. It's only fitting that you're presiding over this because this study on agency appellate systems is something that the Administrative Conference of the United States hasn't looked at it since the last time you looked at it, which was nearly 4 decades ago, the year before the Chevron decision was decided. And before that, James Friedman also took a look at this back in 1969. Both of those reports, as we mentioned in our report, we don't disturb them. I mean, we think that generally everything there is still relevant, and the recommendations that came out of that are relevant as well. Of course, both of those reports dealt with an administrative adjudication landscape that's far different than what we have today. They were both limited to looking at administrative law judges, or what we might think of as APA governed form of adjudication. And this project tried to take a larger view of agency adjudication, even that which takes place outside of the formal provisions of the Administrative Procedure Act. So Matt and I spent a couple years looking at this, and the first thing we did was create some extensive overviews of a dozen appellate programs, after reviewing the literature and consulting with a number of different folks. And then we took those overviews and did in-depth interviews with 1 or 2 or 3 or 4 people at each of the agencies that we were studying. We focused primarily on higher volume agency adjudication to get a sense of how those appellate structures work. The findings in our report, I think the ones that you'll see today are relatively common sense and non-controversial, although I'll look forward to hearing from the conference if they disagree. There's a number of different best practices that were identified during the interviews and our overview and research on each of these agencies. There's also in the report, but not in the recommendations, I think a pretty interesting discussion about the dialogue between courts and agency appellate adjudicators on remand, including when to acquiesce to a circuit court decision and the like. It was fun to find, although it didn't result in a type of recommendation that would be more generally applicable. Kind of just the last thing I want to say on the report is, the underlying big takeaway from the report has to deal with, theorizing or thinking about the objectives of appellate review. One of the interesting and somewhat surprising findings we had of both reviewing all publicly available information, then also interviewing these folks, is that the objectives that they have for their appellate programs aren't always clear. Objectives could include error correction or prevention, interdecisional consistency and uniformity, policymaking, political accountability, management of hearing level adjudication, a broader idea of operational effectiveness, systemic awareness, or maybe even a reduction of federal court litigation. Those are the half dozen or so objectives that were offered during the interviews, but it didn't seem that the agencies had necessarily structured their appellate review process around a particular objective or the multiple objectives that they felt. And so that's definitely a predominant theme in the report that you also see in the draft recommendation. And so in that sense, the kind of big takeaway is not new. This is something that Ron Cass noted in his report, and it's obviously a theme in Jerry Mashaw's path-breaking work on bureaucratic rationality and justice. So this was a really, really fun project to work on. I want to thank all of the agency officials and the scholars that spent countless hours meeting with us to explain how their systems work and help us kind of flesh out the methodology for this project. And then just more on a more personal note, I want to just thank Matt for being such an amazing collaborator on this project. Matt has been such a treasure here at ACUS. I'm sad to see his time end here soon as the head of ACUS, although I'm excited to see who the Biden administration appoints. But I think Matt has just been such an amazing force that brings people together, helps identify issues, and has really continued the legacy of ACUS. So I just want to thank Matt for that, and I'll turn it back over to Ron or Nadine, whoever goes next.
Well, before I turn this over to Nadine, Matt, did you want a rebuttal time?
No, I think I will just extend my thanks to Chris, and I'll find some way to thank him more profoundly, privately, for those nice remarks, and turn it back over to you, Ron. Thank you.
Thank you, Matt. I recognize Nadine Mancini, chair of the committee.
Thanks, Ron. Can you hear me?
Yes.
Great. I want to extend my thanks as well to Matt and Chris for a thorough, illuminating report on a subject that's near and dear to my heart. Our committee discussed the proposed recommendation over the course of 2 productive meetings. Underlying our discussions was a recognition that all appellate systems are obviously not created equal. There are a couple aspects of our deliberations that I think are worth flagging here for you. First, to echo Chris's comments, there was consensus among the members of the committee about the importance of an agency identifying and setting forth the appellate system's objectives. The objectives that the agency sets impact everything from the procedures for appellate review to how cases are selected and decided. So the importance of that initial step informed much of our discussions about the overall recommendation. Second, the committee spent considerable time on the list set forth in paragraph 2, touching upon almost every concept that you see there. The idea was to create more than a laundry list, but to hopefully capture the significant core aspects an agency should reflect upon in promulgating and publishing the regulations governing its appellate system. With that, I just want to thank my fellow committee members as well as the ACUS staff for their unwavering commitment to this work during a challenging time. And I welcome my fellow committee members who are in attendance today to speak to clarify our deliberations to the extent it will benefit the conference's discussion. That's it. Thanks.
Thank you very much, Nadine. My understanding is from the people who were working on the project that you did a great job of shepherding this through. We have a manager's amendment for this recommendation. Is there any objection to the manager's amendment? Without objection, the manager's amendment is approved. There are also 2 council proposed amendments that we'll take up before we move to other amendments. The first of these would revise the last paragraph in the preamble at lines 47 to 51. I think it's fairly clear on the face of the amendment what issue it deals with. If there's any question, we'll answer it. If not, we will ask if there is objection to the council amendment. And again, without objection, that is accepted. The second council amendment is to revise paragraph 1 at lines 52 to 57, which right now on the screen is 51 to 56, which they changed just to give me difficulty when I'm reading through my script. Are there questions about this amendment? Are there any objections? Again, without objection, that amendment is also adopted. We have another pre-submitted amendment from public member Emily Brenner, appearing in a bubble near lines 52 through 57. And I'd like to recognize Emily to explain that amendment. Is Emily with us? There we go. I see you, but I don't hear you.
Hello. So where are we still, what line are we at now?
We're at recommendation number 1.
Okay.
Can I jump in briefly, Ron? So I think Emily's amendment was offered.
So I just thought this read strangely. I don't know that I have a profound substantive point to raise.
Yeah, my understanding.
And my understanding from my communications before the plenary with the staff was that there was a council amendment that this was going to be kind of rolled into. So I apologize for my unpreparedness. I didn't expect to be called upon to discuss this one.
So the council amendment has been adopted. And the question is there additional change to that you wish to have recommended?
I mean, I suspect that the council amendment has taken care of the concern I had, which again was just that I thought it read strangely. Yeah. My intention was not in any way substantive.
Then we will, if you are now withdrawing the additional amendment, we'll move to the next amendment. Unless you want to rewrite the current version.
No, not on the fly, especially. Thank you.
Okay. Are there other, let's see, I think the next pre-submitted amendment is Jonathan Siegel's at lines 76 through 86, which now will be different lines. I think we're now at what? Jonathan, are we at 72?
Part of it's at 73 and the main part is down at 79 through 81.
So I recognize Jonathan Siegel. Make sure you're on our transcript here.
Thank you, Ron. So I thought this was a very good recommendation. I did feel that one thing that was missing was a topic relating to 5 U.S. Code 704 and the case of Darby versus Cisneros, which I am perhaps particularly attuned to because I worked on that case back when I was at the Justice Department. I helped the Solicitor General's office work on that case. And I remember we were all thinking, you know, it's amazing the government has won this point for 50 years in the courts of appeals. But now just because some lawyer took the diabolically clever step of actually reading Section 704 of the APA, we're going to lose it in the Supreme Court 9-0, which we did. But in any event, that case highlights the importance of a detail, which is the following. When a case has reached an initial decision at an agency, and the question is whether to take an appeal within the agency, which is what this recommendation is about, under Section 704, it is very significant, assuming the governing statute does not say anything on this point, it is very significant whether the agency has a regulation requiring that the internal appeal be taken and whether the agency provides that while the internal appeal is taken, the agency action being appealed shall be inoperative, as Section 704 says. Because if if those two conditions are not both met, then the internal appeal is optional, and the party has the option of going directly to judicial review. So therefore, it seems to me we should advise agencies that they should want to say in their regulations whether the action will be inoperative while an internal appeal is being taken, which is what I've put in at letter N, line 79 through 82, and then also whether the internal appeal is a mandatory prerequisite to judicial review, which is perhaps already covered by what's in letter K under recommendation 2, but I thought wasn't totally clear, so I've recommended an addition to that as well. So I would regard these together as being one amendment. The addition to K is perhaps not totally necessary, but it can't hurt to be clear. But the point that's at N, I think, is a needed addition.
Thank you, John. Is there discussion of John's proposed amendment? If anyone wants to be heard on this, signal in the chat and we'll have your mic unmuted.
Ron, it's Nadine. I could say just a couple words.
Okay, Nadine, and then let me recognize Nadine, and then we'll go to John Duffy, who I think wanted to be heard on that as well.
I see Jeff too as well. I'll just be really brief. I thought these were fine. We did discuss in K the possibility of including specific language along the lines that John is proposing. My one suggestion there would be to perhaps just say including whether. Hopefully everything that we say here will be a clear statement. I'm not sure, we need to say it specifically there, so it would just say including whether agency appellate review is a mandatory prerequisite. But the stay point we didn't discuss, and so I think that's a great addition.
Is Nadine's proposed change a friendly amendment to you, John?
That's fine with me. Yes, thank you, Nadine.
Mm-hmm.
I have on my list here John Duffy, Jeff Lovers, and Jack Biermann. Let me recognize John Duffy.
I support the Siegel amendment, though I'd ask that perhaps the two paragraphs, especially the stay paragraph, should be tied together with the mandatory prerequisite to judicial review, which is the rule in the APA, which the Supreme Court backed 9-0 in Darby versus Cisneros. The easiest way to do that, and John, I offer this as a friendly suggestion. If you don't like it, then reject it. Whether in your new N paragraph, just say whether seeking agency appellate review automatically stays the effectiveness of the appealed agency action until the appeal is resolved. I think you need the in there. And then in parentheses, which may be necessary for appellate review to be mandatory, and it just may, because if a statute requires it, then maybe this. But it's I think it's useful to flag agencies, because I think agencies still are, they might think if they put it in their rules, you must take the appeal, that then people will have to take the appeal, and I think it's useful for us as experts to communicate to them, no, if you're just doing it by regulation and there's not a statute, you're going to have to do this stay thing too. Thanks.
Let me ask Jonathan first if Jonathan accepts that as a friendly amendment.
I think that's fine. May I suggest, if we're going to put in that phrase that John Duffy suggested, after mandatory, could we put comma C5 US Code 704 so that agencies will know what we're talking about?
Or perhaps we could put that in a footnote.
Sure.
Let me then recognize, so that's a friendly amendment. We recognize Jeff Lovers.
Thank you. The last two comments by the two Johns have kind of covered my point, although maybe it could be made a little more clear by saying something like, by alluding to the fact that the agency has to issue a rule to do this. Whether the agency has issued a rule pursuant to sections 5 US Code 704 to do blah, blah, blah. But I think you've covered most of my concerns already.
Again, let me recognize John and ask if Jonathan Siegel wants to modify his language any.
I don't think so, although I think Jeff Lubbers just made a good point. Could you scroll up just a bit so we can see the beginning of 2? So I think, Jeff, that what you said is covered because all of 2 is a recommendation that this be published as procedural regulations. So if the agency has complied with what 2 said and has done this as a regulation, that covers the point that you made. Good point, but I think it is covered.
Okay, thank you.
Let me recognize Jack Biermann.
Yeah, I was hoping to speak about a different amendment that I want to offer, a very minor one, but I do say that, I just want to remind you, I don't think we put footnotes in recommendations. So I think the 704 would have to be mentioned in the text if we want to do that.
I'm certainly agnostic.
Yeah, but I think we should finish this one because I want to speak on something different.
We will come back to you right after this. Is there anyone else who wants to speak to the Siegel amendment? Is there any objection to the Siegel amendment? Hearing none, the amendment is adopted.
Wait, there was a comment in the chat. Sorry.
Come on, John.
Let's see. Does Allison Zeeve want to speak on this, or
May I speak on it?
yes?
Allison, I appreciate that comment, but I think moving it perhaps to before until just sounds worse to me. I think it's about as in good a place as it could be for a parenthetical.
Can you hear me?
Yes.
Let me just, for a moment, we need to recognize you, Allison, for the transcript. So Allison Zeeve.
Hi, Allison Zeeve, senior member, senior
fellow.
Whatever. John, I'm not sure where it goes, but I think it's pretty confusing where it is because what it modifies doesn't make any sense. I think I understand what it means because I was listening to the discussion, but I'm not sure I would understand what it meant if I just saw this published as a final recommendation and was trying to figure out what it meant.
If it's congenial to both Jonathan and Allison, perhaps we could remand that particular question to the Committee on Style. And we will treat Jonathan's amendment as adopted. I think, Jack, you now have the floor.
Right, yeah, I wanted to go back to the first.
Jack Biermann.
Jack, sorry. I wanted to go back to the first council amendment because there's no way to do a friendly amendment to a council amendment. And I just wanted to suggest that in what I have is line 49, the phrase is how to implement some of the best practice that follow. I would suggest deleting the words some of, because it says may dictate an agency decision as to whether and how to implement the best practices that follow. Some of, I think, doesn't add anything and sounds weird to me, to put it bluntly.
As a council member, I would accept that. I don't know if any other council member would object to that. If any of the council members would, please indicate so. And this amendment was already adopted without objection. I assume that nobody would object to this change, but again, if there is any objection, please signify right now or signal, and we will hear the objection. And if not, that's treated as part of the adopted council amendment. Are there other amendments? Other comments on the recommendation? let's proceed to a vote on the recommendation.
I had a
Andrew Vollmer has a question.
Yeah, I
Let me
do.
recognize Andrew Vollmer.
Thank you. It's Andy Vollmer. I'm a public member. So I favor the recommendation. Here's my question. As I was reading through it, it seemed that the recommendation leaned towards favoring the creation or establishment of internal appellate review mechanisms. And so I wondered why that was an impression that I had. And I was looking for something in the preamble to refer me to a discussion of the circumstances in which an internal appellate system was a good idea or a bad idea or should be created. And I didn't see it. So it didn't seem to me absolutely clear that internal appellate systems are always a good idea. They have costs and disadvantages. Sometimes seems to me they would make sense. Other times they wouldn't. So I understand this recommendation is not addressed to that, but I was hoping we could have some pointer to somebody who had the same question I did as they read through the recommendation. And so I thought a good place might be paragraph 3. It used to be line 17. It's where the preamble refers, no, sorry, it's just the third paragraph of the preamble. It's, you've just passed it. It's where we talk about the 2 earlier recommendations. And so I've looked back at them and they do have some discussion about criteria or circumstances. They're both very heavy on the need for statutory authorization, which occurred to me as an absolute prerequisite. So I have a suggested amendment. It goes on too long. And Ron, I'll do what you want on it. I'm happy to read it so people hear it. But if no one else has this concern, I'm also happy just to drop it. I was just trying to express a question that came into my mind as I read through the recommendation.
With that option, let me call first, Andy, on Nadine as chair of the committee and see if she has a reaction to this. Let me recognize Nadine Mancini.
Thanks, Ron. That didn't cross my mind in reading it, but obviously if it crossed yours, it's something we should discuss. I would turn it to Chris and/or Matt to address in terms of the report that they did. They may have some insight here.
Would Matt or Chris like to speak to this?
Matt, do you want me to take that or?
Yeah, why don't you take it, and if I have any additional thoughts, I'll add them.
So let me recognize Chris Walker.
So we, what I understood our charge to be was to pick up off of recommendation 2016-4 and just assuming that agency appellate review exists at an agency. And nowhere in the report do we recommend its creation or anything like that. We're just identifying best practices for such review. I don't know, it's hard in the abstract without knowing the language that wants to be suggested. We did not in our report, and Matt, you can correct me if I'm wrong, and in our interviews, we didn't focus at all on whether it should exist. We took the 12 agencies that we decided to focus on that already had it and explored how they did it. So part of me is somewhat nervous about making statements, at least if we're trying to make them based on the report and the scope of the report on whether it should exist or not. And we really don't have anything, I get in my mind, anything from our study that would shed a lot of light on that. Although I guess if you read our report, you will get the sense that we're pretty big fans of appellate review within an agency before it gets to a federal court.
Yeah, if I may, Ron,
let me recognize Let me recognize Matt Weiner.
Okay, thank you, Ron. I'm glad that Chris mentioned recommendation 2016-4. I believe that recommendation, and I don't know if we ought to look at it now. I believe the conference already recommended quote, higher level review of hearing level decisions. I'm just, I can actually just, let me just read from, Gavin just handed me recommendation 2016-4. Paragraph 26 says, apart from any opportunity for reconsideration by the decision maker, procedural regulation should provide for a higher level review of initial adjudicatory decisions. Agencies should give parties an opportunity to file exceptions and make arguments to the reviewing authority, so forth and so on. So the issue is addressed in recommendation 2016-4. I suppose, of course, there would be situations in which the hearing level adjudication was actually conducted by the agency head, in which case you probably would not want, or probably could not provide for higher level review. But I guess it's a little hard for me to address Andy's point without getting some specific context or specific instances in which this may be a concern.
Let me ask Andy if he wants to respond to that, or whether he's satisfied with the responses from the consultants and the chair.
Well, I'm always satisfied hearing from Matt. But so it seems to me that a critical point here is the need for statutory authority. And in fact, if you look back at the other two recommendations that this recommendation cites, the one in 68 and the one in 83, they are recommendations for statutory action, congressional action. And I think recommendation 2016-4, Matt, which is actually quoted it's the first sentence of this whole recommendation, first couple sentences, omits the need for some sort of thought and discussion about statutory authority. And if it just recommends appellate systems. So that troubles me, because this recommendation leans very heavily in favor of them, and I don't think we should be. I think they're leaning heavily in favor of appellate review, even though apparently there's a strong, the committee favors them. It's just that they do burden private parties considerably. They delay. There's a bias problem with internal administrative proceedings. There are situations in which an agency will have very few adjudications, like an enforcement agency, where there's no need for any appellate review, or appeals to the agency heads are sufficient, and you would not want to insert an intermediate appellate system because it would be inefficient. So I just don't think it's that easy of a question. I think it depends on a lot of circumstances. I certainly see an agency that has lots and lots of initial adjudications would have a far greater desire and need for intermediate appellate systems. But anyway, my point is it does depend on a variety of circumstances. And my only thought is that in this paragraph beginning on line 17, that we let the reader know that if they want some further discussion of the circumstances in which appellate review mechanisms would be appropriate, that they could look back at these other recommendations.
Ron, may I respond to one thing there?
Yes, Matt Weiner.
Andy just substituted intermediate appellate review for appellate review. And as I mean, the report did not advocate intermediate appellate review, and I don't read the recommendation to advocate intermediate appellate review in an agency such as the NLRB, the SEC, where there is no intermediate appellate review, and an ALJ's decision is reviewed directly by the agency head. It's actually true on any number of agencies, or an agency, and in some agencies it's an agency head delegate. But I don't, I don't see anything in here that recommends that, say at the SEC, and that's obviously an agency Andy knows well, that an intermediate appellate body be interposed between the ALJ and the commission itself.
Are there any other comments on this? I will say, just as a reader of the report, Andy, I had taken it to be a report suggesting best practices for appellate review rather than recommending whether there should or should not be appellate review more generally. Are there other comments? Yes.
Just add one other.
I recognize Chris Walker.
And not to the other concern some of us may have is if there isn't final decision-making authority, appellate review, that the adjudicators may not be constitutional. And I think that's another, thing. And I think Matt hit it well with, we're not advocating necessarily for intermediate appellate review, but I would feel really uncomfortable, and I guess I'm recused from this as a consultant this time, but if I were a public member, I would feel very uncomfortable suggesting that there doesn't need to be final agency decision-making authority of adjudicator decisions.
Are there other comments or questions? Are people ready to proceed to a vote on the recommendation? Is that?
I have a
Are you
comment.
raising your hand, Alan?
Yes, and I also put
I
it in.
recognize Alan Morrison.
This relates to the recommendations 14 through 18 on page 7, I guess it is now. I have always been someone who didn't like the use of the words appropriate scattered throughout recommendations. These 4 recommendations, or 3 actually, 14 through 17, has gone to new extremes. I point to you number 17. As appropriate, appellate systems should communicate with agency rule writers and other policymakers, and as appropriate, institutionalized, communicate, so forth and so on, to address issues, whether they should be addressed. I would not want to take up the Assembly's time to do all the editing, but I ask that the Committee on Style see whether the use of appropriate is appropriate in all of these cases, and ask that the drafters of future recommendations see if we can have some less use of appropriate when of course it's not appropriate to do so.
Well, we will appropriate the Committee on Style for that purpose.
Thank you.
Are there other comments or questions before we proceed to a vote? If we are ready for a vote, let me ask the voting members to unmute yourself, which is the opposite of what I'm normally asked. Is everyone unmuted? No. Those who are in favor of adopting the recommendation, please say aye.
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 Those who are opposed, please say nay. I think the ayes have it. And the recommendation is adopted. Our thanks to Matt and to Chris and to Nadine and all the committee members who worked on this. Our appreciation of all you've done. We know it's a lot of work, and we're grateful too. And with that, I think I turn the gavel back over to Matt leaves his role as co-consultant and takes up his role of acting chairman once again.
Thank you very much, Ron, for presiding over this recommendation. I have nothing further to say other than that we'll adjourn for the day and resume tomorrow morning at 10 a.m. when we'll hear remarks from Paul Ray, the administrator of OIRA. Thank you very much, everyone.
Thank you.